Attendance from his family, surgery was not done. He is now again taken into jail, Hazrat Lordship. My lord, he is suffering from appendicitis. So, my lord, I am praying for listing the matter today at 2, Lordship, because CD was received earlier. Notice was supposed to be served, Lordship. And my learned friend was asked to take instructions to whether notice is served or not. So,
If we take it up at 2 today,
Lordship,
from where will you have the information?
Lordship, at least
Of the-
amicus curiae may be engaged, and thereafter matter may be taken on tomorrow or day after tomorrow, Lordship. Otherwise, vacation is ahead, Lordship.
It's not a criminal, it's a criminal appeal, no?
No, Lordship. Bail,
Bail,
Lordship,
bail, man.
BA.
Less or more than 7 years, what is the
Lordship.
less than 7 years or more than 7 years? What is
7 years. Also 6 years.
10 hours? No?
60 days in
Can we
custody.
have the report if he gives you the detail? Can we give it a try?
Lordship.
Huh? You give him the bail number.
Lordship. I am giving the mention memo, Lordship.
You give the mention memo to the court. He must also know
Lordship.
which report he has to ask for.
Lordship, Lordship.
So if at 2 we get a report,
Lordship.
we'll see.
Lordship, I will give the details, Lordship.
Oblige, Lordship. Or otherwise it will be.
Lordship.
Well, for listing of a bail application. of
Just a minute. Just trying to calculate it out. If at 2 we do not have the report also, we can have it listed for tomorrow then. Huh? We'll have it at 2. We'll try to see if the report is complete. We'll appoint an amicus. He can give a copy. We'll try it tomorrow then.
Oblige, Lordship.
Yes.
Well, for listing a bail application on 22nd Thursday. Okay.
53 of
53. Yes.
Lordship, what instruction I would like to dot press, Lordship?
Why?
Because this was to approach trial court.
Has he approached or is he going to approach?
Earlier once approach,
Ah,
then again we will approach because some progress in the trial is taken.
no.
Yes, yes.
Oh, yes.
Yes.
That one.
Yes.
Mr. AZ Ahmed, Learned Counsel appearing for the petitioner, has submitted that he is under instructions
Yes.
not to press this bail application in the present form and to seek liberty to approach the appropriate trial court.
Yes.
Stop. Prayer not being objected to by the Learned Counsel for the Learned PP. This bail petition is closed, giving liberty to the petitioner to approach the appropriate trial court with prayers as briefed. Yes.
Maybe. Bail application, antecedent application may be allowed to move in connected with item number 37. In this case, CDS come or PM are not come. My land will inform me.
Today's
Today. PM are not received. So my PM, it may be taken today.
connected with item 37. Connected with item number what?
37.
37.
37.
We can have it listed together. We'll take it along with that.
My lord.
Okay. For today,
Today it will be better, otherwise.
take it tomorrow. We'll keep a track of that number. We'll have it listed together. Yes.
Item number 10.
10. Yes.
But I am for the petitioner, my lord. Here there are some development on the case, my lord. So I want to file one affidavit to blot and record all the developments, my lord. So I pay for 3 weeks time, my lord.
You've informed the other side.
I have informed all the counsels.
The Learned Counsel for the petitioner submits that he is under instructions to file an additional affidavit to bring on record certain developments. Full stop. He has also submitted that he has taken the consent from the other side to make a mention of the matter. Full stop. Accordingly, list this matter again after, again on, give us a date.
After 3 weeks, I need
Give us a date. 16th? On 16th of February 2026.
May I please, your lordship?
Yes,
Lordship, I have to mention item number 46. Item
46.
40 order, my lord. In this
Yes.
matter, my lord, supposed to consider some interim stay, my lord, on receivable LCR, but the record shows the LCR has not been received. So may I pray, my lord, so record may be called for to fix another date in the month of February. LCR not received, my lord. So, my lord, I cannot make prayer for interim, so I'm making prayer for adjournment.
The learned, no, heard Mr. So-and-so and also the learned PP. The lower court records are yet to be received. Full
Yes,
stop.
Lord.
Issue reminder. List
10th
this
of
matter
February.
again on,
10th of February, my lord.
on the 10th of February 2026,
Deep
along with the LCR.
Deeply obliged.
Interim prayers will be considered on receipt of LCR.
Deeply obliged.
Yes.
Please, your lordship.
Ah,
Lordship, paying for listing of a BA, your lordship, one connected matter has been listed before this honorable court for tomorrow, your lordship. Item number 58, your lordship.
tomorrow also.
Much
But
obliged.
here we are only taking up matters which are more,
Yes,
more than 7 years.
Matter has been listed, your lordship.
Okay. Tomorrow.
Item number 19.
19, 19. Scan copy of the TCR is here. Huh? We'll take up the matter if we see there is some difficulty in considering the press, we'll give it. Someone is behind the bar. Is it not? When do you want it?
First week of the February. Candidate close.
Mr. So-and-so on council appearing for the petitioner has prayed that the matter may be taken up after a week. And PP has submitted that the scanned copy of the TCR has been received. List this matter again on 5th of February 2026.
May it please the lordship.
Yes,
With the consent of the other side, I beg to mention item number 44, lordship.
44.
Yes, lordship.
Yes.
10 February.
Typically, in this matter, if they, I mean, if not 10 February.
10 February.
Learned counsel for the petitioner, with the consent of the learned counsel for the respondent, has prayed that the matter may be taken up on the 10th of February. Full stop. Prayer allowed, list the matter on 10th of February. Item number 44, you said.
Yes, lordship.
There's an IA also. What is the IA for?
On the last date, we have filed our objection, lordship.
Yes.
Doubly obliged.
May I please, your lordship, I beg to mention item number 38 and 41, lordship.
38.
Yes, lordship. And
Yes.
41, lordship. I have CD not received, lordship.
Huh?
CD not received, lordship. Yes. I am on interim, lordship.
Heard Ms. So-and-so learned counsel appearing for the petitioner. Learned PP submits that the CD has not yet been received. We'll stop list again on 9th of February, 9th of February. 9th of February 2026, by which time the VP shall ensure the receipt of the case diary. Interim protection granted earlier to continue till the next date.
Another prayer, lordship.
Ah.
Listing of a bail application tomorrow, lordship.
Tomorrow. Okay.
Filed on 7th of this month.
May I please, your lordship. Lordship, I beg to mention item number 40, my lord.
40.
For adjournment.
40.
Today only, my lord. Kindly the matter may be fixed. on
When do you want
tomorrow.
it?
Tomorrow, my lord, kindly.
We have received that.
Receive the-
CD
We'll
is
take it day after tomorrow. Day after tomorrow.
Highly obliged.
The prayer of the learned counsel for the petitioner lists this matter again on which day after tomorrow? 22nd. 22nd of January 2026. The learned PP submits that the case diary has been received. He would retain the same. Yeah,
May it please, your lordship, I am praying for listing of a BA, my lord, for tomorrow, my lord, if possible.
it will be day after tomorrow.
Deeply of.
ये पेंसिल भी ऑप्शन है पेंसिल ना पेन भी दाग नहीं करूंगा एक यार
May,
yes sir
may I please, lordship. Item 1 and 28,
Hmm.
these two, 1 and 28
Ah,
Same, your lordship.
in
In fact, your lordship, in these
28
two-
received.
herein, your lordship, 180 days they have completed it.
Hmm.
In item one, it is 182 days, and in item 22, it will be 184 days.
20, item
28.
28. Yes, sir. What do you say? Not submitted.
As per my instruction, no such it.
When? What about this medical part?
Medical.
Have you received the medical documents
Yes,
or not?
we have received the medical documents,
Hmm.
your lordship, but in petition number 3, your lordship, his condition is not good. He has
When can you have the information, sir? When can you have the information?
at 2 only, your lordship.
At 2. We'll take this up at 2. All right.
May I please, your lordship? My lord, this is a petition where I have prayed for quashing of the entire proceedings, my lord.
Ah,
My lord, the effect of the case is like that due to a storm, my lord, there were some slag in the overhead wires.
hmm.
And the person who unfortunately, my lord, deceased, he went under those wires to cut grass or something of that sort. And while he tried to, my lord, get up,
Hmm.
he got electrocuted. And thereafter, then FIR was filed against the officers of the APDCL. Perhaps the CD is here, my lord. Ase noy? TCR ase no? The TCR is here, my lord. But then one thing, my lord, is missing, perhaps, my lord, that electrical accident inquiry report. My lord, under 163 of the Electricity Act, my lord, 161 of the Electricity Act, whenever there is an accident of like nature, my lord, and investigation is carried out by the department itself, my lord.
Hmm.
And that is an independent inquiry, my lord, which is done by the department to assess as to what has happened, my
Some
lord.
electrical inspector does.
Yes, my lord. That report is not there, my lord. That may perhaps be called for, my lord. The PP may be directed to produce that, my lord.
You make the APDCL a party.
APDCL is not a
Oh,
party.
it's independent
Because-
investigator. You have to make
yeah.
him a party.
Because ultimately it's a 482 petition, my lord. We have made the complainant a party and we have made the state a party, my lord. So, my lord, the
But if
state
you are
can-
depending
state can-
upon some report, if you
No,
let some
it's not a
report-
question of dependency because, my lord, lordship, what I want to say is, in the entire case, my lord, this case has been registered under negligence and the charge sheet has been filed under me, against me.
The-
Now to show that, my lord,
if
that I
we-
was not negligent at any point of time,
If we go through the FIR,
my lord.
it says that complaints had been made that the wire is hanging low
Yes.
for quite some time.
Yes, my lord.
The officers who had received the complaint,
Yes, did not act upon it. So.
all persons who
so-
are concerned with their electrical subdivision,
My lord.
It's
So
not
what I
something
say
which
is,
is
my
out of
lord,
the blue.
that the list of documents which is appended along with the charge sheet, my lord, should show that because there is an allegation that some complaints had been given, that complaint, my lord, ought to have been there. That complaint is not there, my lord. So just to make up a story, my lord, to get benefits of financial, my lord, because of the
that
death.
would be that financial
So that
benefit
is
is
why,
not,
that is why what I say, my lord,
not in
even
any
at this
way-
stage, and I also during his investigation has not relied upon that, my lord, electrical accident inquiry report, my lord.
Show us why the trial should not proceed. What is the what is
trial
wrong in it?
Not proceed because of the fact that ultimately, my lord, the ingredients of negligence is not made out here. And my lord, this is an abuse of the process of law if I am today made to, my lord, face the trial.
If a high voltage wire is hanging at a place where a man who sits down and stands up hits his head on it,
My lord.
and the electrical officers who are in that area who are responsible for that area, if they do not even know about it, I don't know.
My lord, the case of
You will
the
have to draw a line
petitioner
between
as
criminal
projected-
negligence and negligence.
The case as has been projected is that on the earlier night, there was a storm. In the wee hours of the morning, this has happened. My lord, we are officers in a cadre, we are also, my lord, human, my lord. That notice had to
Not-
come to us, my lord, my lord,
Not wee hours, it is at 11:30 AM in the morning.
11:30 in the morning.
Is it
my lord.
wee hours?
11:30 in the morning, my lord. We come to
Suraj
the
Kanti,
office at
these-
10 AM, my lord, at 10:30 AM. my
These
lord.
are arguments which would show whether you were negligent or not. That
My
is a
lord,
matter for the trial court to decide.
My only
Therefore, it need
request,
to show us some procedural lapse, something to show that.
That
no,
is the
this not
procedural
in
lapse, my
not a
lord.
case even.
that is the procedural lapse because that accident inquiry report has not been taken into consideration by the IO. And I am not named in the FIR, my lord. Now, if he says that, my lord, that because that allegation was given some time back and we had not acted upon it, my lord, then, my lord, that particular, my lord, report, whatever was submitted or complained, that ought to have been a part of the records, my lord.
We'll
And that
admit
is
it,
the basis of the, my lord,
we will admit it,
my lord.
and it's already understood.
The TCR is here, my lord. Let it, let this report be called for. Pillar PPM be directed to call for, bring the report, my lord. And thereafter, a date may be fixed, my lord. We can, my lord, settle out this matter, my lord.
That is a separate body. We do not want to burden the,
If you lost it direct, my lord, there's no
state for
problem.
nothing.
If I can make the APDCL a party, my lord. I can interfere on the direction.
not
of
the
lordship.
APDCL, the inspector, whether he has done it or not. Have you made a statement that there is no report?
My lord,
Have you made a statement somewhere that the report has not been called for?
no, that I have
Then-
not stated, my lord, but I said, my lord,
Where?
at paragraph 5, I have stated
Hmm.
in the last portion of paragraph 5, and the petitioners were roped in only with a view to extort money from them as they were not locally the said locality. Further, the allegations in the FIR about the submission of an LA's complaint is also not correct, as the petitioners have not come across any such complaint in connection with the low hanging overhead wire.
You have the TCR. We'll decide it now. You have the TCR.
And in paragraph 8, we have stated what is the actual case, my lord, how it happened and when it happened.
You have not taken that ground in the para 8. What have you said?
In para 8, I have, my lord, given that what is the actual fact that had taken place, my lord. It was a hail and thunderstorm on the previous night,
Hmm.
due to which, my lord, there was a slag. And by the time we came to know about it and we rushed to that place, my lord, this accident had already taken place.
Not finding anything to.
Now, my lord,
This is something which the trial would see whether there was a storm in the earlier night, whether there was negligence on their part, whether it
Sir, that
happened,
will be
whether it was an
reflected-
accident.
that will be reflected by this, my lord, electrical accident inquiry report. And my lord, it is also the settled law. If, my lord, I can produce some documents of sterling quality, my lord, then, my lord, this court, my lord, is, my lord, you should see it, my lord. Because that is an unimpeachable, my lord, piece of document, my lord. If, my lord, that, my lord,
We'll admit this,
Ma'am.
since the,
Ma'am.
these things are there, already you are under protection, there is a
Ma'am.
stay,
my lord.
and we are not calling for any report of the electrical inspector. If you want to move an application, we'll pass an order on that, but
My
the
lord.
person who's not a party here, we will not be burdening the state out of the blue.
File an application.
Huh?
Liberty may be given to me, I'll file. an
We
application.
don't want to burden the state with responsibilities of you asking for an electrical report.
My lord, it's just a phone call away, my lord. It's not a burden
It's
at
just
all.
an RTI.
My lord.
File 1. This was an accident. Did you make an electrical report? Matter ends. We'll decide it right now.
My lord.
We'll not burden the state.
Give me that liberty. my
The scan copy of the LCR has been, of the TCR has been received. Oh. Matter is ready for final disposal is already there. The learned counsel for the petition has submitted that the report of the electrical inspector with regard to the incident would be vital to decide the petition. Full stop. The petitioner would be at liberty to move appropriate application to call for such record, since the electrical inspector is not a party in the present case. Stop, list the matter again on
Let it be after 15th of February, my lord.
18th of February 2026, when an attempt would be made to
20, my lord.
20th of February 2026, when an attempt would be made to dispose the matter. Who is he? The informant. Was there hail and storm the night before?
Yeah, what happened?
Was there a hail and storm on the night before?
Was
Ah.
that information I have not.
Then
My part.
what more should, that is his only ground.
One thing in that. They are saying that the reminder or the representation was not given. Repeatedly on 2018, on 2019 and 2018 again. We have submitted.
Do we have that on record, sir?
This
Have you
we
brought it on
documents
record?
We have made.
Huh?
These documents we have made. For this.
This court would be very loath to act like a gram panchayat where I'll be asking, please give me a piece of paper. Yes, thank you, sir. Then he will say, no, I don't have that piece of paper. I would like to reply to it.
I'll submit.
When did you file your wakalatnama?
It's 2024.
2024?
And with that,
Yes.
this document.
Thereafter, did you have the copies of these complaints? Yes.
Yes,
You got the copies. You did not find it. You did not find it fit to file your affidavit in this matter, right? You are saying that it was not listed. Did you try to get it listed? No. Have you filed an application for modification of the interim order? No. Then why do you make these submissions? We have wasted another 4 minutes. Is it not? We are fixing it on the 20th. Have all your documents on record. Show us that it should not be interfered with. He would show that it is liable to be interfered with. Yes. Mr. So-and-so, Learned Counsel, appearing for the respondent number 2. That will be at the top, huh? Mr. Chaudhary for petitioner, Mr. So-and-so, PP, and Mr. So-and-so, Learned Counsel, appearing for the respondent number 2. Thereafter, the rest of the order will come, huh?
My lord, the interim orders passed earlier will continue.
Interim orders passed earlier shall continue.
I am deeply obliged.
Yes.
We have filed a petition for proceeding quashing, my lord, for quashing the proceeding, my lord. The matter is settled, my lord. The one-time alimony also received by the informant, my lord. They also filed an affidavit, my lord. This matter is compromised. And Krishna is a army personnel, my lord. It's very difficult to attend each and every date, my lord.
Just a minute. What was the allegation against you?
Allegation was kindly see at page 15, 498A, my lord.
498A,
My lord.
506, yes, unless the
Page 16, my lord.
respondent number 2 appears.
Yes, my lord. They have filed affidavit, my lord.
They have,
Yes,
appeared.
yes, in our favor, my lord.
What does the affidavit say?
They are now not pressing the matter, my lord, the matter is compromised and they uh, supported our case, my lord.
What kind of 498A did you do? Mantarika Muslim court marriage 2013, 2020. Where is that FIR?
FIR page 16, my lord.
Mr. Goswami. Oh, Mr. Prashar. The FIR says that it has been lodged in 2020. Marriage is of 13. Allegations are that from the initial stages of the marriage, he had an affair with someone, he was going around with ladies. And thereafter, if we see, he demanded 1.5 lakhs from the lady's parent, filed a divorce case, maintenance case is pending. And then there is threatening of triple talaq. And in the divorce case, she is being pressurized to give her consent.
They have no objection.
That is, no, even the nature of the allegations threatening to give threatening that I should give consent to divorce. We'll set it aside. We'll set it aside then, based on the affidavit, huh? You have disposed of, dikha dijiye. This will be disposed of. We'll pass the order in the. Huh? 498A? The only harassment is give consent for divorce. And she has filed an affidavit. We have amicably settled it. I have got my money. Thank you. Disposed of, huh? Allowed. All right.
Your Lordship, it's a petition, Lordship. And the last date, Your Lordship, a report was called for with regard to the FIRs lodged by the petitioner, Your Lordship, from the PS Udalguri, Your Lordship.
In terms of the order, it is 15 minutes. I wrote a letter today, for SP, I sent the email also. But subsequently, I am not followed. On that day, 16, I called him. And but no subsequent report has been received.
What are the
And
allegations against the petitioners? NI case.
And
When he went to the court, there are threatening in our notice. That's
Hmm.
that is the issue. Where there is the actual threatening, that was the Korea of the court.
No, they had made some FIRs.
Yes, yes.
Whether are those FIRs? When can we have that?
Well,
Otherwise, the NI case is just waiting. He issued a check. Someone is waiting for his money.
yes.
Eh?
One
You do stop threatening him.
during
Stop threatening him. They will go and appear. You will have your money. You threaten him on the road, and then you.
One, my lord.
Ah.
Petitioner himself.
Ah.
The current trial.
Ah.
Next date, my lord, he filed the FIR.
Yes. Because you saw that you are
On
losing
that
the
very
case.
particular date, my lord, they have not made the
Because,
FIR.
because perhaps you felt that you may not be able to make out a case once the defense is now coming in. So stop threatening them, everything will be okay. Huh? Anyway.
Otherwise, regarding that, during this vacation, I have not followed.
But
But I think that was-
we'll have it on 13th of February.
maybe short date, long date it will be difficult.
Okay. Then we'll have it on 2nd of February.
Uh,
At the request, Miss So-and-so appears, huh?
But second is 3rd February.
Heard.
3rd February.
Miss So-and-so Learned Counsel appearing for the petitioner, also heard Learned PP, and you are appearing for? Item number 9, huh? Take their attendance. You give it on a piece of paper. You give it on a piece of paper, it helps her. The Learned PP has submitted that. He is awaiting the information required by this court by the order dated 15/12/2025, and he prays that the matter may be taken up on the 3rd of February 2026. Full stop. Accordingly, list this matter on the 3rd of February 2026, enabling the
It may
PP to
continue,
have
Your
the
Lordship. The interim orders may continue.
the interim orders passed earlier shall continue till
Any
then.
lordship-
File an affidavit, we will not threaten. That we will not threaten.
No,
And Your Lordship, with regard to item number 8, Your Lordship, the service with the respondent number 2 has been complete, Your Lordship, as per office note dated.
We will just have a
9/1.
report from the
Yes.
police,
Yes.
whether you are actually under threat or not.
Obliged, Your Lordship.
It will be very dangerous if we keep transferring matters like this. Everybody will say, I am under threat. Yes.
Service awaited. As per office note dated 9/1/2026.
What was the charge against you? Take him on. Office note dated 9/1/2026 reflects that the neither AD card nor unserved notice or service report has been received in the concerned section. List again on 12th of February 2026. Awaiting report of service on the respondent number 2.
Obliged, my lord.
Yes, sir.
The appellant has been, my lord, convicted
Wow.
for RI for 7 years, lordship under section 20, B, Roman 2B 29 of
Hmm.
29 of the NPS Act.
Hmm.
Now, lordship, he is in a jail for 2 years, 9 months, 18 days, lordship. At this stage, my LCR has been called for,
Received.
that is received, lordship. Now, we have an interim, interlocutory application, lordship,
Wow.
for suspension of sentence and bail, lordship.
Hmm.
The case is, lordship, the prosecution case was, lordship, before the trial court.
Hmm.
The substances were, my lord, found in a bus,
Uh,
but no passengers were interrogated. Only handyman and, my lord, driver was examined. And the inspector who, my lord, had investigated the case, lordship, was not present at the place, lordship.
hmm.
Two, my lord, one home guard and, my lord, other constable had searched the, my lord, vehicle, lordship. Now during evidence, lordship, it is very clear that the no specific evidence that the substance were recovered from the possession of the petitioner. 3 persons were there, lordship. One has been convicted.
When can we take it up? See, these 3 persons were traveling in a bus. The bag was under the seat. One was in the bunker, and they have been. Where is the evidence to show that they were the only 3 persons in the bus? Driver and handyman did not. The bag did not belong to the driver and the handyman. And what about the other co-passengers? है ना? Since not from their body, and if it is not well proved that it has to be their bag and no one else's.
Under the seat or.
On the bunk, it could be by the driver or the handyman for that. For that matter, it can be the driver and the handyman. So you are taking their witness. So you have to show that, huh? Was there any evidence to that effect or not? If the bag is connected to them, or how do you say that the bag was there? That is all we need to see. When? 3 years already behind bars. So
Tomorrow or day after tomorrow. Tomorrow may be taken up.
not tomorrow. We'll have it on 29th. 29th or Thursday. It is 22nd. 20. Ha.
Lost.
Heard Mr. So-and-so on a council appearing for the appellant. Also heard Mr. Parashar on a PP. He has prayed for some time to go through the PCR, which has been received. List the matter again on the 22nd
Obliged.
of January.
Obliged.
TCR or TCR or direct TCR to scan copy to no. Huh? Scan original to ages again. Sub scan copy. Yes, yes, yes.
Like sometime by head objection by law, I'm declared just half that man. And for
You are for respondent number
mine.
2,
Yes.
8/12/2025.
Seba. No. Respond number 2. Seba complete just Seba is a party. Seba 3, sir. 17, 20. Seba 3.
Interim. There is no stay, sir.
No stay, my lord. Here is a the case is something like this, my lord. The petitioner, he was alleged to have, my lord, forged the registration certificate of the respondent number 2.
Huh.
There is a gap of almost six years, my lord, between the 2 passing examinations, my lord, 2 dates. But my lord, Seba says, my registration, my metric certificates, etc., everything are there. It's genuine. But the registration number is something wrong with the registration number. And I got the job which I'm working, I got it much before that. I did not take any benefit of that because it's a grade 4 job. Class 8 was necessary. I already got the job much before. And I retired also.
No, it is not about that. Whether there is a forgery or not.
Only extent of forgery, he froze my registration certificate and he appeared.
Are we on the same? Are we on the same case? 1/3/13?
14 was called.
No. 13.
Not well. 14.
Oh, I
13 is
had
the-
I had 14. Sorry.
NI case.
I made a mistake.
And I was trying to look around, trying to find your name.
Oh, I heard 14. I'm sorry. I'm sorry.
It's okay. Yes, 13. Who is there? Who is for the petitioner? None.
Item 14.
Yes, we are taking up 14, Mr. Datta. 14.
I have deleted, I have only for 1 week time. I will file
For what?
objection. I will file objection.
Let him say why he wants. Let us see whether there is something in the matter or not.
Yes, it picked up 3/9/2026, my lord, for CC, my lord.
3/9,
Yes, my lord, there no urgency.
3 September.
2026. No, sorry, my lord,
9/3.
9/3. Yeah, my lord.
He lodged an FIR saying that you forged his certificate.
No, this registration number for appearing in matriculation.
And for appearing in the matriculation examination.
Yes. That too after a gap of almost 15 years, man, if I'm not wrong. 15 years.
And that certificate had not been used by you for any purpose.
Any purpose, because I got my job much earlier. And Sebas report, your lordship will
So
find it.
why is he aggrieved that there is a forgery?
He is aggrieved because he said because of him, he did not pass matriculation or he could not get any job. That's why he's saying he's aggrieved.
Oh,
Now, lordship will see Sebas report at page 62. That's very interesting. Yes, maybe there's some mistake somewhere. I don't know what is the problem. But Sebas says that my HSLC certificate, roll number, admit card, everything is genuine. It's as per the records, it's available. But my registration is the same with him.
it's one of these, whether you committed a forgery or not has to be seen by the trial court. So why this petition?
Because this is a case where apparently the investigation did not the charge shall file the charge sheet.
No, the registration number is wrong.
Wrong.
It is wrong.
It is wrong.
Now the
As per Seba, I don't know because this is what the Seba says. But what
So
Seba
now-
says is that
Page 62.
so now the investigating authority has said that please try him whether he has forged it or not. You
investigating
will show whether you have forged it or not.
investigating authority has not considered the Seba's report properly. It has just said,
Maybe so
No, but then
that'll
this-
be in the trial court.
and I have to face the entire trial. This will abuse the process of the court because of the fact that lordship see the Sebas reports because it says if I have
If the investigation is wrong, should this court be interfering?
if I sit for I just pose myself this query. If I sit in the examination his name, I might get an entry into the examination hall. To that extent, it's okay. But how can I have a proper documentation with the Seba of my mark sheets, admit cards, everything? Maybe in the admit card or in the somewhere registration number is wrongly written. That may be the case. I don't know. But
And
what
to-
has
And to whom does the registration number belong to?
registration number belongs to him as per Seba.
The rest of the documents are yours, and you don't have a registration. And you don't have a registration.
No registration.
No, that
That
is
admit card, that
Yes.
roll number must be against a registration number.
yes, that is there. So that numbers as per Seba pertains to him. But everything else is mine. I have passed matriculation as per Seba. I have my mark sheet is as per Seba. They say that's why I'm saying page 62. Their records.
And then all these things, whether you committed a forgery or not, has to be tried out by the trial.
I understand that. I truly understand that.
And just because you have to go through a trial, can it be the only reason for us to interfere? That is
Because
what I was thinking.
if I'm made to face this trial on the basis of some wrong investigation or some wrong material,
Mm.
I just face the criminal consequences of the case.
That is what leads to acquittal.
I
Every
understand.
investigation, we would not like. to
I
take it.
understand, but then this is a case which can be perhaps
We'll admit it and fix it for a hearing when?
as early as possible. Because if it's possible for 9/3, then it'll be better. So 3/9, sorry.
We'll place it before 3/9. We
Yes.
don't go so. By when will you file your objections?
Of February.
First week of February. We'll have it on the 16th of February. 16th of February. is-
I have also made Seba a party. I made them a party. If they can produce the records, I don't know what will.
Are they here?
But their service is complete on that.
Possibly shows their name.
No, my lord.
Huh?
Their name not which one.
This is item 14, na? Huh?
Service is complete, my lord.
Take this down. Heard Mr. M. Datta, learned counsel appearing for the petitioner. Also heard the learned APP and Mr. Swenso, learned counsel appearing for the respondent number 2. The learned counsel for the respondent number 2 has prayed for a week's time to file their objections to this criminal petition. Full stop. Allowing such time, list this matter again on the 16th of February 2026. On which day, full stop. the name of the standing council Seba
My lord.
to be reflected in the cause list hereafter.
In fact, my lord, SEBA says that it is not, there is no mechanism to detect incorrect registration also. That's also SEBA says.
This sitting this side, it is very difficult to express as to what might have happened.
In fact, while accepting this brief, I returned my learned friend for about 3 occasions. I said nothing doing. Thereafter, seeing these points.
Yeah, please.
Yes, sir.
Record was called for, my lord, in this case, my lord.
Hmm.
Case praying for quashing of the proceeding, my lord.
Hmm.
My lord, kindly see the inquiry report, the turn to the FIR, my lord, page 14, my lord.
Case diary and status
Yeah.
report is something this court had asked for. What do you have? Case diary and status report were called for. Nothing. Yes, sir.
My lord, interim order may be allowed, my lord. For staying the operation of the proceeding, my lord. Inquiry, my lord. But the case is this, my lord, genuine Indian citizen, my lord. The SI border, my lord, call him, my lord. Call him and inquire his document, my lord. And declare his documents are old. And he filed this inquiry report and the OC, my lord, registered a case under criminal section, my lord,
Hmm.
without verifying the records. And my lord, he,
The case has to be registered first, then the record should be verified
yes,
perhaps.
yes, yes.
Heard Mr. A.J. Atia, learned counsel appearing for the petitioner, also heard the learned PP appearing for the state respondent. Notice in the case diary was called for initially by the order dated 24/9/2025 and 17/12/2025 fixing today. Full stop. List this matter again on 29th of January 2026, by which day the investigating authority shall provide copy of the CD to the learned PP for production before this case, failing which the investigating authority may be required to be present before this court. Orders may follow to require the investigating authority to remain present in the court. Huh?
All right.
May I please allow? But this is an application under section 528 of the BNSS for quashing the proceedings that has been initiated wrongly by the CGM, and that's why there is a support of the case of our own High Court as the apex court matter. But what happened? A CR case was filed pertaining the incident of 2018 in 2024. That her daughter was tortured and she was physically assaulted, and there was a physical relation also established with her daughter, and the CR case was filed before the CGM.
After 6 years of the incident.
Yes,
Alleged
2018.
incident.
And my lord, in that case, my lord, learned CGM has issued summons after examining the person. So my lord, case proceeded. In the meantime, she again initiated one other CR case before the CGM and got it with the direction that to OC to register a case. Subsequently. So subsequently another GR case was registered. And in that case, charge sheet has been filed. Earlier case was dropped. Maybe, whatever.
Cases.
Scan copy was called for, it is not.
No,
Understand, but if from the documents, could you see whether it is the same, if it is the same set of allegations? Two proceedings is what is disturbing.
Priyanka Chopra's
One of them
case-
has to proceed. One of them we will allow to proceed. But if it is two proceedings based on the same set of facts,
the law, settled law is, my lord, Nanette court have to be inquired
you-
first after
have you-
154, whether any case is pending or not.
Have you received summons in the second case?
Yes,
In the second case where it has been charge sheeted, you have received summons. You are appearing there.
yes, yes. Now, 6th February, it is fixed, my lord.
Ah.
So, my lord, LCR may be called for and I may be given a protection.
Hmm?
Maybe fix on third.
We'll fix it on third.
For what, my lord? LCR may be called for.
LCR will be called for. We will just try to see
Yes,
if
yes,
there-
we will examine it, my lord.
if there are, if the set of allegation is the same, second one goes, the first one will continue.
No, no, not that.
This
my
will
lord.
become supplementary, yes.
The question is that whether case can be initiated
That is what
without
we are
being
saying.
confirmed from the
The,
OC or SP.
the second one goes and the first one will continue. This will be a part of
Yes.
the investigation.
LCR may be.
They can use it as a part of the
Yes,
investigation, but they
yes,
will
yes.
not have a second case against you.
Yes, exactly.
Third of February, sir. Heard Mr. F. Biswas, Learned Counsel, appearing for the petitioner. Also heard Mr. K.K. Parashar, Learned Counsel, Learned PP. The office note dated, and what about that report on this? Huh? The office note dated 9/1/2026 shows that no wakalatnama has been. No, respondent number 2, I think. Respondent number 2
Yes.
is the.
Yes, we have made in party, my lord. We have taken steps also.
Strike out that order. Only that part will remain. Heard Mr. S. Biswas, Learned Counsel for the petitioner. Also heard Mr. K.K. Parasar, Learned APP appearing in the matter. Full stop. The order dated 16/12/2025 records that Miss A.S. Pradhani, Learned Counsel, had entered appearance before this court for the respondent number 2 and 3, submitting that she would be filing her wakalatnama. Full stop. The office note dated 9/1/2026 reflects that no wakalatnama has been received by the section till date. Full stop. The office note also reflects that that reminder had been issued to transmit the case record of special session special case number 45 of 2025 on 19/12/2025. But the records are yet to be received. Full stop. Issue reminder to the concerned trial court informing that the matter is now being fixed on the 3rd of February 2026, by which date the scanned copy of the trial court record shall be made available without fail. Full stop. The Learned PP is requested to make an attempt to inform the respondent number 2 and 3 through the concerned police station regarding the non-filing of wakalatnama by their instructed counsel. We are making a request to try and see if you can do it. Or we delete it from the order, you do it on.
In that case, one of the service complete. Now some is not filing, but.
Oh, I'll file, we can appoint an amicus curiae. Full stop. Acha, etu Learned Counsel, Learned PP is requested to cut it. To cut it. Since none has entered appearance for the respondent number 2 and 3, despite the fact that on the last occasion, a counsel had submitted that they would file their wakalatnama, this court deems it fit to appoint Srimati Priyanki Das, Learned Counsel, is amicus curiae to assist the court on the next date fixed. Learned Counsel for the petitioner may provide a copy of the petition to the learned amicus curiae appointed by the court.
But till then, further proceeding may statement.
No, your next date is 6th.
6.
We have fixed it on the 3rd. We may well set it aside before that. Interim prayers for.
I'm sorry, next date is 4th February. Let it come on 3rd.
It is coming up on 3rd. interim consideration of the interim prayer made by the learned counsel for the petitioner shall be made on the next date fixed.
Lordship, I am appearing on behalf of S. Raman, Lordship. He is out of station, Lordship. It may be written for today, Lordship.
ECI নাকি?
LCI.
Huh?
LCI.
You're appearing. Now, this person, he wants to enter appearance by keeping the non-bailable warrants on in the proclamation and attachment order on by setting it aside. He wants to appear and participate. Maybe. We always don't grant you time. Why should we grant you time? Yes, what objection? He wants to go and participate. Can be allowed. Take your instruction if it can be allowed. He is not objecting. We will say that the non-bailable warrants will be kept in abeyance.
Yes.
Lordship already PNA issued.
PNA.
And
He never received a summon.
Lordship, they received someone and thereafter, issued the PNA. At first NBW and then PNA.
Did he receive it?
Lordship,
Did he receive the summon is the only issue.
Lord. Annexure 3, Lordship. Issue summons to him.
Summons were issued, was it
But
received?
subsequent order is there, Lordship, and then Lordship, annexure 4 by the order dated 7/1,
Just a minute.
accused is absconded, issue PNA.
Who says accused absconded? On what basis?
Order dated 7/1,
Huh?
7/1/25.
Yes.
Page 3.
What do you say about, you want that time? When do you want it?
For next week, Lordship.
Order dated 15/7. Accused absent with steps. He had notice of the case.
Lordship,
Huh?
today, Lordship. Only today.
Only today. Okay, list this matter again tomorrow.
Tomorrow, Lordship.
No.
Next week, Lordship.
28th of February at the request of the learned counsel for the petitioner. List this matter again on the 28th of January 2026.
Like,
I'm like.
And being item 30.
I am the respondent, my lord.
Huh?
I'm the respondent. So I have filed a problem and I am raising the petition is absent. Their name is Mr. Fukon, they are church with that. It is a very there, so. And the case is regarding that reason of say,
Hmm.
I shouldn't say, he should have.
There is no stay.
No,
There is no stay. None appears for the petitioner on call list again on 10th of February 2026. Mr. A. Rashid, learned counsel appears for the respondent. Mr. So-and-so PP appears for the state.
Item 18.
May I please, Your Lordship? Senior is in another court. Kindly.
Time being.
20.
Well, the PW 1 examined. And PW 2, instead of examining the victim, his brother examined on 8/1.
Victim not examined.
Not,
till now.
but every time she filing petition, taking examination, my lord.
Hmm.
So 232 days as on today. So by question land of detention, my lord.
The intent of the court is to allow the victim to adduce evidence.
Yes.
If the trial court has deemed it fit to allow her that opportunity one more time, should we interfere in that? When is the next date?
Next 2022.
22 January?
One, yes.
And then we'll have it immediately thereafter. 28th.
That may be observed, my lord.
But
that-
you have to get us the certified
I will-
copy of the
my lord.
statement recorded.
Yes. And if the victim will not bear my case.
What is
will
the
be-
allegation in the FIR?
Informant examined the murder. Actually, there's a love affairs. And therefore, they are, both the guardians, they decided to their marriage after attaining the majority. Now suddenly murder.
But he's a good man apparently. He has taken the photographs and he's saying, marry me.
Yes.
He's a good man.
Just 3 and 4 months.
Ah. That we remember that case, but look at the FIR. Now he's blackmailing her, demanding either a relationship or marriage. He's a good man. He wants to marry.
After marriage, I am now still ready, my lord.
You are still ready for the
My
marriage.
lord.
First come out, then we will get you married. List this matter again on 29th of January 2026. Since it has been submitted by the learned counsel for the petitioner that the statement of the victim could not be recorded on the 8th of January 2026
There are several occasions.
and it is now slated to be recorded on 22nd of January 2026.
If not recorded, my lord, then my case may be considered on 29, my lord.
That we need not record
will
that,
observe.
that we will remember, don't worry. When we remember you trying to marry her, we'll remember the other part of it.
Lordship,
Hmm.
kindly pass over the matter for the day.
For the day. Why?
My senior is not present today.
At the request of the learned counsel for the petitioner, list this matter again on. Pick a date.
20, after 20? 20, after 25?
30th of January 2026.
My lord, petitioner is behind the bar since 75 days, my lord.
Ah.
He has a 13-month-old daughter, my lord.
Hmm.
And there is no one to look after her, my lord. Considering the length
What
of
happened to the mother?
mother committed suicide. This is the case, my lord.
And the allegation is you are involved.
Lord,
Huh?
at the time of occurrence, my lord, petitioner was not at home, my lord.
Not necessary. Not
It's a
necessary.
third time for CB, my lord. Still not received, my lord.
Just a minute. This woman got married with sister since May 411.
Page 8 is the FIR, my lord. Page number 8, type copy.
How do Where is the child now, baby? With whom?
Under custody of the other person, my lord, of the family. Uncles are.
No, your family members or the wife's family members? Where is the child?
Not confirmed, my lord.
Then you don't even know where the child is. You are saying that the child needs my care. Huh? If you are so concerned with the child, you should have told us. Find out. Learned PP submits that the case diary is not yet received. The first order calling for the case diary is of 9/12/2025. Is it? Is of 9/12/2025, full stop. The list again on 29/1/2026, by which the learned PP shall ensure that the case diary is made available.
23 was successful.
Please, your lordship.
Charge sheet has been submitted.
Submitted lordship, on violation is there, lordship.
What violation?
48, lordship.
48. Can you show us?
Page number 38, lordship. Page 38, lordship.
Page 38. Yes. Ground of arrest.
Ground of arrest.
Huh?
Relative, lordship.
Huh?
To the relative of the.
To the relative, yes. And it was not received by the relative.
Received lordship notice, but that is addressed to the brother Aminul Islam. In this notice said that you are being arrested. Yeah, but no name is there who has been arrested.
Where is it you are being arrested?
Yes, merit lordship. Merit. যোৱা ইংৰাজী 4/11/2025 তাৰিখে ৰাতি 8:11 বজাত মংগল গছুলিয়াই এক গোপন সূত্ৰে জানিব পাৰে যে চৌৰঙ্গী মোৰ ৱাৰ্ড নম্বৰ 13 এলেকাত নিচা জাতীয় দ্ৰব্য অবৈধভাৱে লোক এজনে বিক্ৰী কৰাৰ উদ্দেশ্যে মজুত কৰি ৰাখে। মতে পঞ্জিত দৰজ নং 0/4/2025 ইংৰাজী মর্মে থানার ভারপ্রাপ্ত বিষয়া মহোদয় মঙ্গল গোসরিয়া ও সংগ্রাম সহ নির্দেশ করে আর উক্ত আরক্ষীর নির্দেশ মতে আপনার ঘৰত উপস্থিত সাক্ষীৰ সাক্ষাতত ভিডিঅগ্ৰাফি কৰি ঘৰ তালাচী কৰিছিল আৰু তালাচী কালত উক্ত আৰক্ষীৰ দলটো ঘৰৰ পৰা এটা প্লাষ্টিক মোনাৰ আপুনি লুকাই ৰখা অবৈধ নিচা জাতীয় দ্ৰব্য
Just tell us one thing.
Yes, Lordship.
This page 35A. Page 35A. Can you come to page 35A? Annexure F.
Lordship.
Is it the complete copy that you have given us? Or is it only the first page of the notice you have given us?
So there is also translation is there, Lordship.
I am asking page 35A. It is a notice under 47, not under 48. It is under 47. There is only one page. Where is the other part? 47 is half the notice. So what is reflected in page 38 and 39, that Assamese portion?
Lordship,
We just wanted to compare if it is the same thing which is there in page 35 in 47.
Lordship.
Right?
47.
So if it is a copy of 47,
No, it is
in a hurry he has written Apunak. Apunar bhai ne likhi pela Apunak. You know the reasons. It is already given.
Page number 32, Lordship, the another page that is 47, page number 32 is there, Lordship.
Page number 32 is the 47 notice.
47, under section 47 notice, yeah.
It is a copy of
Grants of arrest to the person arrested.
it is a copy of that. Whatever was given to the arrested person, same things have been just copied and given to the
Yes, Lordship. in
relative.
48. But But the last portion will get lordship,
আপোনাক arrest কৰা হৈছে।
lordship. That is the part.
Now it is,
It is
can
the
there be a-
violation, lordship. If addressed to someone, then saying that you are arrested in this case, that is
And-
totally, I'm not that person, lordship.
he could not understand that his brother has been arrested and this is a notice for the brother.
Maybe understand lordship, but as per this notice, lordship, as per Prabhu Prakasto and Bihan Kumar lordship, that is specifically to be given who is arrested. how
Rubber band is stretchable. After a particular point of time,
Lordship,
it
but,
breaks. It stretches no further.
lordship, but in this case.
আপোনাক
I
আৰু
say-
আপোনাৰ ভাই, if you want to say that the notice is incomplete only because of that,
Yes, lordship.
it can be a rejection. If you want to file an affidavit to bring on record any other affidavit or approach the lower court because the charge sheet has been filed, it is your choice.
I'll bring the charge sheet, lordship.
Eh?
I'll bring the charge sheet in the record, lordship.
You want it to be pending here.
Lordship. Maybe allowed to file additional
It's
evidence.
fine. Why don't you try your hand there?
Trial court already on some rejected, lordship, will not consider.
Prior to charge sheet.
One rejected
Prior to charge sheet.
charge sheet.
Now the charge sheet is there. No further investigation required. I will not run away. I will give the best of the bails. You may have a case there.
Lordship.
What to do?
Lordship, maybe, direction may be given to approach that trial. And one child is there.
We are not pressurizing you. Don't take this to be a pressurizing that we want to do. It will be hanging here for nothing.
Direction may be given, lordship.
Hmm?
Usko.
Mr. Swain Solanar counsel appear for the petitioner, also Mr. K.K. Prashar, learned APP, who has submitted that the charge sheet has been submitted in the matter, full stop. The learned counsel for the petitioner submits that he may be granted the liberty to approach the appropriate trial court to pray for regular bail in view of the fact that the charge sheet has been submitted. Stop. The charge sheet has been submitted by CS number.
457 of the 25,
Hmm.
dated 23/11/25.
Stop. Without determining the merits of the argument of the learned counsel for the petitioner regarding the validity of the notice served under section 48, comma, the present bail application is closed,
One,
allowing the petitioner to, yes,
one submission may be recorded, lordship. One child is there.
record.
Only 3 years, lordship. That may be considered.
Granting the petitioner the liberty to approach the learned trial court with appropriate application, full stop. It has been submitted by the learned counsel for the petitioner that the petitioner is the father of a 13-month-old child. And
3 years.
with,
3-year-old. 3-year-old.
3-year-old child. And there, who requires his care, stop, the same grounds may be agitated before the learned trial court while paying for bail.
Oblast.
Disposed.
Well, all conditions, my lord, whatever were given, my lord, we fulfill, my lord, and we appeared before the police station. That we have replied by way of an 87 affidavit, my lord, page 41, 3 and 4, my lord. We just sat there for some time and we are allowed to move out, my lord, because nothing to be recorded by police, my lord. No statement, my lord. 3 and 4 we have stated in para 3 and 4.
Unfortunately, the affidavit is perhaps.
It has come, my lord, we told it.
Oh, yes.
Suddenly of night. No mobile phone and all those conditions are fulfilled, my lord.
Yes, sir. Any custodial interrogation further necessary?
Contact is not good.
Huh?
Contact is not good.
Now, after getting bail, conduct is good, my lord.
Keeping that conduct in mind, we had granted the bail because he was supposed to study.
Yes, it's a clear for online.
Hmm?
He is talking about the, when Lordship granted interim, my lord, that part prior to interim being granted, my lord. Subsequent to interim, all the.
Now he does not have access to internet or social
Nothing,
media
none.
activities anymore. The only thing that is, his parents are now conscious enough. Some charge sheet, etc. comes, it will be taken care of. Heard Mr. B.K. Mahajan, our counsel appearing for the petitioner, also heard Mr. D.P. Goswami, learned APP appearing in the matter. By the order dated 19/12/2025, this court had granted an interim bail to the petitioner following to the subject to the following conditions. Subject to the following conditions. A to D. Order dated 19/12. একদম পাতলাকে আমি পেন্সিল দিয়ে দিছো Today an additional affidavit has been filed by the petitioners stating that the directions given by this, the conditions given by this court have been complied with, and also an assurance has been made that the petitioner shall continue to cooperate with the investigation as and when required. Stop. A perusal of the case diary does not reflect that custodial interrogation of the petitioner is required at this stage. Stop. In view of the above, the interim protection granted to the petitioner by order dated 19/12 is made absolute. It is, however, made clear that the petitioner shall continue to abide by all the conditions laid down in the order dated 19/12/2025, and any violation of the same, if brought to the notice of this court, may entail cancellation of the privilege of bail granted to him.
My lord, my lord.
Bail application disposed of. Yes. Yes, sir.
Already 70 days made. Already 70 days made.
Oh.
From
What did the petitioner do?
103 million.
Let the case diary come.
Yes.
Learned PP has submitted that the case diary is yet awaited. Full stop. List again on 29/1/2026 to enable the learned PP to have case diary. 29/1.
26.
20 same.
60 days is over to them. 60 days is getting over to them.
Today.
Intermediate quantity.
Yes, sir. It is 12 o'clock. 60 days is getting over today, 2 o'clock. They may file a charge sheet. We don't know.
They may obtain instructions.
2 o'clock. We have it at 2 o'clock. At 2.
Deep level.
27.
Made peace or lodge. This is a regular bail application. Offenses under 103 BNS. Lordship will have the FIR at page 16. If I may-
Page 16.
16. Lordship. May I read, Lord? I have the honor to state that around 3:30 PM on 16/5/25, Sri Jayanta Saharia assaulted his wife, my sister-in-law, Srimati Minu Saharia, aged about 40 years, with an intention of killing her, following certain family issues when no other person was available at the house. Having seen it, The neighbors brought my sister-in-law from the house and got her admitted into Deomarne Community Health Center. As her condition was critical, doctor referred her to Mongolway Civil Hospital, where from she was taken to GMCH. But doctor declared my sister-in-law dead while she was undergoing treatment. Lordship will please thereafter have age 29. So it is charge sheeted. I am 248 days in custody, Lordship. My only prayer at this stage, perhaps, Lordship, there are only 5 witnesses. There are only 5 witnesses. The material witnesses have been examined. 3 of them have been examined. Only the official witnesses are left. My difficulty, Lordship, is that there is a 14-year-old child out of the marriage. And he is unattended for, Lordship. My prayer is that at this stage, since only the official witnesses are left.
The assault was in which manner?
Lordship,
Assault was by what? What did you
Lordship,
hit
that
the
is
wife with?
The evidence has come. Lordship, that is not clear also from the evidence. Lordship may have.
No, it was with bare hands, it was with a stick, it
Lordship,
was
it is
with a
not-
kick, it was with a sword,
It is not
dao.
clear from the record, Lordship. Will I am also.
And suspect on 14th-25. There are 5 PWs, 3 PWs were examined already. And so last, it was 29, the trial is going on regular and smooth manner. Instead of the trial, if not become 1 PW number 2, Lordship. I will keep it there.
No, the eyewitness is what?
That the nature of the assault is
Reconduction?
perhaps not clear.
Hmm?
The nature of the assault is perhaps not clear from the testimony.
Even in the assault. That is what we are trying to see. Repeatedly is what we were waiting for.
PW2 is the
Child, the nephew.
The witnesses are your brothers and your sister, your niece.
Yes, unrelated. The informant was not present. The informant, Lordship, was not present, the brother-in-law. He was informed by PW3. Yes.
Who?
Yes,
it is from
the informant. PW3 is the wife.
PW2 is clear.
PW?
2.
17 years old. PW2 is
It is on your drunken stage,
eh?
Yeah, drunken stage,
There is some
and
Assaulted repeatedly is what? Yes.
after releasing him, how much
But,
you will
It's
take care
not
of
as
his
if
child.
there is no
But-
chance of conviction.
Lordship, but we'll also.
It is
see
not
that
a case
the
where we can
official
say that
witnesses-
there is no chance of conviction and we can allow you the bail. Hmm? Three have been
Examined. 2 are left, Lordship, the IO and the doctor is left, only officially. On that ground.
Only around Lordship to take care of his child, 14 years of child.
Yes,
After releasing him, how much he will take care of his child? You're talking.
perhaps not at this. Lordship will please see that only official witnesses are left and even otherwise.
It is not
Lordship will be
about
subject-
official witnesses when That kind of a prayer we can consider in appropriate cases, but here is a case where by going by the evidence, we cannot even say that the chances of a conviction is minimal.
I appreciate it.
That be so. They are not inclined at this stage. But Mr. So-and-so, and the council are paying for the petitioner also heard the learned PP. The trial court records as requisitioned have been received and produced by this court. The statement of 3 of the witnesses for the prosecution have been recorded. And the learned counsel for the petitioner submits that only 2 official witnesses remain to be examined. And in view of the fact that the petitioner has a 14-year-old son to look after, a prayer for grant of bail to him at this stage may be considered by this court. We have gone through the contents of the trial court records. In view of the evidence available on record and available on record and the nature and gravity of the offense alleged, we are not inclined to consider the bail petition at this stage. Full stop. The bail petition is accordingly rejected at this stage. After all the witnesses are taken, come back, we'll see.
Obliged.
I will move to the I will move to the trial court.
Go to the trial court. The learned PP has submitted that the charge sheet in the present case has been submitted by CS number
72/25, dated 26/12/25.
Stop. The learned counsel for the petitioner prays that the present that the petitioner may be allowed the liberty to approach the learned trial court to pray for regular bail. Full stop. Prayer is allowed. This bail application is closed, allowing the petitioner to approach the learned trial court to pray for regular bail. DA disposed of.
Already appeared, my lord.
9/1/26, or someone appears. You'd appear for the informant. Yes.
Your lordship, my lord, ultimately, initially there was a case, then the compromise taken place saying that after attaining majority, both will take place marriage, my lord. This is also there, my lord. We have annexed that agreement also, my lord. Thereafter, again, second time, because they got a better option. So my lord, they filed the present case, my lord. So ultimately, boy is 19 years, my lord. On the 19.
Scan copy easily be syndicated.
Already charge sheet file, my lord, on 5/12/25. And date of occurrence 6/10. FIR is page 18. Sorry, forgot it.
Page 9 is the first FIR. What is
No.
page 9?
No, the present one.
Page 9 is?
Page 9 is the present FIR, my lord. Dated 7/10/25.
First fire and closed person now withdraw the.
Withdrawal order, second, my lord, first one is not encalled, but actually, my lord, withdrawal order is there, my lord. Page photo.
Page 9 is the FIR, then?
Then your lordship will find tax sheet. Tax sheet file on 5/12/25. Page, your lordship will find page, it starts from 13.
Page 19.
13 is from
page 19.
The FIR first, 19. 18 is the forwarding report, 19 is start. Then your lordship will find last one. There's agreement
Then order is page 30.
Just a minute.
They are called dual by both the parties.
72 rejection or
Hmm.
agreement to withdraw the case.
30, page 30.
This agreement is made on
Page 31 is the handwritten matter, signature of informant is also there.
whose signature is it?
That is written I. No?
Sopita Bibi. Sopita Bibi is who, the informant?
Yes. Kindly see my Udgar petition for page 30.
Huh?
Page 30,
Ah.
English, then the handwritten is page 31. And then applicant Sabita Bibi, that is informant. In reference
The
to the
issue-
cited above, I have the honor to state that dated so he has lodged the case before the Belashipaka police station due to the mistake of fact.
Hmm.
After lodging this case, I along with the villagers and the guardians of the accused person mutually settled the dispute amicably. Accordingly, in the presence of villagers, I decided to withdraw the case on the basis of the compromise. If the OC Belashipaka so and so is on the basis of that, I have no any source of objection as I am not willing to proceed with the case.
Hmm.
Basically, agreement was made that after attaining the majority that we have stated in our petition, then marriage will take place, man. The agreement.
This is dated when?
Agreement is page 20, 728, your kindness, agreement one. On the basis that agreement, that was, yes. Page 28, your lordship, and this is the original handwritten one, my agreement.
29th of August.
Yes.
28th of August. Okay. Now, can this agreement be the basis? For
No, I am
being
not
held?
saying, I am saying the circumstances are high, ultimately what will happen, a charge sheet also already filed. Informant has come. Further custody is the requirement, already there is an initial agreement. Now, maybe for some reasons, my lord, I think may be settled also out of the court, also. Maybe, my lord. So, because informant already appear, I don't know, my lord. But initially, that was the proposal, my lord. I am not saying this should be the basis of granting of bail, my lord. But it gives an idea that, my lord, there is something is there, my lord. And relation is 19 years old boy, my lord.
Hmm?
And already today is 47 days. He will face Sakshir filed my lord, trial will start, he will face the consequence, whatever is there, my lord.
Hmm.
Only for the custody is my lord. Keeping in view the age of the boy.
Withdraw my decision. Agreement do Baba.
Hmm. Yes.
But then, looking at this 14 years, 14 years, 9 months.
Hmm.
But that's now lordship the charges and file later on. Otherwise, they are said they are of the terms of the considering the age of the person.
Hmm.
Earlier, they once a compromise lordship, they pressurized lordship that happened, lordship, again, the same thing repeated. They have done lordship without finding it is. And now he comes out. Again, compromise. Minimum 2 witnesses maybe and the C is out of it. The minimum is the.
What does the medical?
Medical care, after Sarship medical care.
Refused.
Yes, my lord. Ultimately, relation was to get married, my lord.
Yeah.
Because of the age, my lord. Trial, not yet, charge has not been framed till today, my lord. The only for the purpose of keeping him, my lord.
At this stage, sir, we are finding it a bit difficult. What do you say?
Yes, Lordship, please make
It's a bit difficult at this stage.
But when it will start, my charge not yet been framed, my lord.
Could be, but when the statement,
My lord, between statement, same thing will come, my lord.
Hmm?
Supposing, my lord, same thing.
see,
will come. She
if,
refused medical, my lord.
even if we go by the agreement you had shown us, undated,
Oh, that is, my lord, but A is there, my lord. That
Huh?
order is, that prayer is there before the court. That page 30.
huh?
Page 30 is the in pursuance to the agreement that was made by.
Page 30 where?
Page 30 is the petition to the OC, my lord, in terms of the
You will
agreement.
see the signature down below is an Assamese.
Page
The
20
upper part of the entire application is in English.
No,
The
this one,
handwriting is not of a,
that don't have so much, it is the handwriting, my lord, but kindly see my page 27, stamp is there, my lord.
where? Page
Date is there,
20?
my lord, page 27. Date is 29/8/25. Top,
29.8.
yes,
This is notarized.
yes, sir. Notarized one.
This is notarized.
Notarized magistrate that normally.
This is notarized.
Your lordship, may I check the, my lord, signature of the informant and the present one, my lord?
Hmm?
The FIR.
Hmm?
FIR has signature will be there, my lord. Signature is not, it is not
Signature
in
is-
dispute, my lord. What he is saying, my lord, friend, my lord, he is saying there's some pressure.
At this stage, sir,
My lord,
finding it a bit difficult.
only thing, about how long it will, your lordship knows, my lord, very much, because has not yet been framed. Then notice will go, my lord, somebody will take time, whether that will go, my lord.
At
Well,
this stage-
relation is there, my lord.
Huh?
I am not denying it, she refused the medical also, my lord.
Hmm.
So ultimately, what will happen, what will the result?
Refusal of medical cannot be taken to be a ground that she was interested in whatever had happened.
No, that refusal means it gives some meaning, my lord. It comes in my
Not,
favor.
not necessary.
That ultimately what will happen?
Not necessary.
Six will not be there, my lord. 6 box will not be there, my lord, if it is there, my lord, if that is there.
We are finding it a bit difficult, sir. At this stage.
Then in that case, my lord, up to date,
Mhm.
let the, after the charge, framing of charge, my lord, your lordship, mercy, my lord. Keeping pending, my lord, that will be better.
Yes, we can do that.
One starts,
But Mr. H.R. Chaudhary, learned counsel appearing for the petition, learned senior counsel appearing for the petitioner assisted by Ms. So-and-so. Also heard the learned PP and Ms. Aswini, learned counsel who has put in appearance on behalf of the respondent number 2. The trial court record, scan copy of the trial court records received reveal that the
Transparent, then another day, how long it should be kept pending? No, whether charge frame after our. What is the prejudice, my lord? Suppose if it is kept, how he will be prejudiced, my lord?
that the charge sheet was submitted and
5/12/25, my lord.
the 5/12/25 and the special case was registered on 17/12/2025. Full stop. The learned senior counsel has prayed that the matter may be taken up after the framing of charges. Stop. Accordingly, list this matter again on 20th of February, what, or little later. Tell us your choice.
20.
20. Framing of charges, we do not know. 12th of February, 2026.
Alright.
Full stop. Call for the updated status of the TCR,
TCR.
if any proceedings are conducted by that time. Yes.
My lord, lady is in custody, my lord, for the offense committed by the husband, my.
Yes.
NDPS, my lord. She is residing in another campus, and because husband was not available, so she was taken to custody. And to that. 4 years, my lord, child. Two child, one is 9 years, one is 4 years, man.
86 kilo.
She is not FIR named also, man.
Huh?
She is not FIR named.
What is
also.
her name? By when? 27th. We can have it on the 27th.
To our information, she is taking what it may be on the way also. They got better. Well, let it be on 22. If it does not come, I know your loss will be fixed on 22.
The case diary is called for by the order dated 7/1/2026 is yet to be received. Full stop. Place the matter again on 22/1/2026
Let us see, my lord.
at the request of the Learned Senior Council appearing for the petition.
Mate, please.
Yes, sir.
Well, I was not there, my lord. At the
No, no.
Well, it's a regular bail, my lord.
Huh.
Well, the scan copy was called for, my lord. And I have gone through the scan copy, my lord.
Huh.
Well, I have not found that notice under section 47 and 40 of the BNSS, my lord.
I have still not found, but I have flagged one production warrant of it when he was first come. It is stated that it has been there. It mentioned that you got the instruction. Rounds are obvious here. But in the
If your records do not contain that notice,
I have not known it is sufficiently given or not. It may be ineligible, there may be other documents may be there.
we are not on
But
that.
in the warrant. for the-
Where
I
is
have
that?
checked.
So, do you-
Otherwise, my lord, 359 grams of heroin.
Huh?
59 grams of heroin recovered.
In his collection. Has then already been framed.
Charge framed.
Charge framed. Charges framed on lottery. From 1912, 2025.
That copy of the 47 and 48 are to be part of the record.
No, I have not found. also.
It is not there.
But in the.
So, shall we ask the,
Only said it that-
shall we, are we required to ask the CGM from where he has written that?
that it may be done.
Not,
If it is being done in a routine manner,
madam.
may not be correct.
It can be.
If typed out orders are being given. Have you stated anywhere in your petition that the
Yes, my lord.
47 and 48?
Yes, my lord. Page 7, paragraph 6, my lord.
And was this ground taken?
Yes, but categorically stated.
No, was it taken before the session judge or the special judge?
No, my lord.
Mhm.
As because this is the only bail application pending here, my lord.
What I wanted to see is that if it was raised before the
Yes,
sessions
sir.
court,
My lord.
they might have answered it saying yes or no.
My lord. Or your lordship may call for the, my lord, if any, my lord.
No, the scan copy is there already.
Yes, already there, my lord.
Already there. It
It's
doesn't
already there. It's
contain
not, it's
the,
not available, my lord.
it is not available. Heard Mr. Learned Counsel appearing for the petitioner, also heard the Learned PP. The Learned Counsel for the petitioner has stressed that the petitioner was deprived of the notices required to be served under section 47 and 48. thereby leading to violation of the rights under Article 21 of the Constitution of India as held by the Apex Court. Full stop. The trial court records received on requisition had been perused, and this court does not find copies of the notices under the aforesaid section being served upon the accused / arrested person or on the friend, relative, etc. nominated by the arrested person. Full stop. The order dated 27/5/2025 of the Judicial Magistrate First Class Nagaon reflects that the learned Judicial Magistrate had seen the forwarding report of the IO showing the ground of arrest, notice under section 47 of the BNSS, and notice under section 48 of the BNSS. Full stop. Since such notices are not found on record in the scan copy forwarded to this court, a copy of this order be forwarded to the whom we send it to the Sessions Court.
Yes, madam, trial court, madam.
To the learned trial court to verify as to whether such notices are on record. And submit a report. Full stop. In case such notices are found on record, scan copies of the same be forwarded to this court by the next date fixed. Full stop.
Nagaon.
The same learned trial court.
Right.
List this matter again on. We'll have it on the 29th. On the 29th of January 2026. Full stop. Along with the report, list on 29/1/2026, along with the report of the learned trial court regarding the presence or absence of the notices under section 47 and 48.
Lordship, may kindly mention, my lord, Lordship had said, my lord, scan copy of the trial court as well as the case diary also. It's diaries also.
And the learned people shall also requisition the case diary.
Case diary is available.
Oh, it is available. It is not there in the case diary also.
Yes, case diary is available. It is not there, my lord.
Not only in the records of the scan copy of the trial court, or in the case diary.
I am obliged.
Any luck? Any luck?
My lord.
Any luck on the issue raised yesterday?
No, my lord. As regards, my lord, that apathy will not make their application can survive, my lord. That has to go, my lord. And for the Lordship Authority on that Kayal, that is, I have been told, my lord, I have not read it, my lord, that if any apathy is there, my lord, it is to the benefit of the
Kamidi Anand. What we had said was this. We do not know how. Records produced by the Learned Standing Council for the Customs do not divulge the means by which the notice was sent to the family or to any of the authorities in the jurisdiction of the residence of the wife. And that prior to 2 months of sending such notice, any attempt had been made by the respondent custom department to follow up whether the notices were actually served. That has been one ground for granting the bail. We'll take it up at 2 if it is convenient.
My lord.
Yes.
Communicated with the IO also.
Hmm.
Today morning, Lordship. Yes, like this very difficult one for their part to communicate, to follow up the.
It is not their part.
To follow up the communication that they served or not.
Or he says it is not their part. We'll make it a weekly way. Because here we have said, it may be true that due to prevailing factors like the wife of the petitioner residing in another state may be the reason for the respondents in failing to serve a notice immediately after the arrest of the petitioner. However, some follow-up action has to be taken. You can go through this. We'll take it up at 2.
My lord.
Mr.
My lord,
Mahajan can
another
also go
part,
through.
Lordship may elaborate for their betterment, my lord. 48(3), that says, first of all, my lord, the constitutional provision. From it flows the intention of the legislature 48(3), my lord. My lord, 48(3), in all cases, my lord, police to comply with those requirements, my lord. If the book is kept, then everything Lordship's query, my lord, whether it was sent to Haryana, definitely sent, no action taken, those would be incorporated in within that 48(3), my lord. Because this is statutory provision, it is to be complied with. They do not even touch it, my lord. They
Because-
don't even have a book.
Because
possibly.
even if you go to civil law, something which is unrelated to this, your sending a notice does not matter. Send to the proper address, send to a given address, send to somewhere. How do you see that? It has to be by registered AD, it has to be by something. Then that receipt has to come before we say that yes, notice has been served, even in our court cases. So here you have sent a WT message. Can you then forget about it? You are putting a man behind bars.
Yes.
Ultimate aim is to give him that benefit that you can now fight for your defense.
Absolutely.
If you don't follow that up, he loses that right.
My
That is what the Supreme Court is trying to stop.
My lord.
Give them all the rights. Whether they can defend it or not is a
My
separate
lord.
issue.
At 2, my lord.
At 2,
My
you
lord.
can go through this.
Yes.
Find out.
My lord.
If required, we'll elaborate this also.
My lord.
May it please your lordship.
Yes, sir.
The service completed. Sir. Whether service has been completed or not.
Yes. What happened to the examinations?
Oh, he couldn't see it, my lord, as lordship has given the interim because of the mental stress, my lord. He couldn't.
So starting to complete that, Lordship.
So
Service is complete.
amicus query needs to be appointed then.
Heard Mr. B.M. Declan Council appearing for the petitioner. Also heard Mr. Goswami, an additional public prosecutor, who submits that as per report received, the service on the respondent number 2 is complete. However, none appears for the respondent number 2 today. In such circumstances, this court appoints a list conduction. 8 number কোন আছে? B. Chaudhary as the amicus curiae to assist the matter. Learned counsel for the petitioner shall supply a copy of this petition to the learned amicus curiae appointed. List this matter again on
Maybe on Friday, the Thursday, my lord, if possible.
Okay. Notice complete. Amicus.
and 22/1/2026.
My lord?
22/1.
Yes, yes, my lord. Much obliged, my lord.
May I please, Your Lord? Well, petitioner, season bank manager, allegation of disbursement of loan, my lord, on the basis of some fictitious, my lord, document. That is the allegation, my lord. I am not the signatory of those documents. I was not the even field officer. On the basis of the report of the field officer, the loans were disbursed at that relevant point of time. In fact, to that same cause of action, I lost the first FIR. Subsequently, there are few more FIRs on the basis of the same cause of action. In all cases, I have been granted privilege of anticipatory bail, my lord. This is the last FIR, my lord, which is pending. I have already appeared, my lord, based on the documentary evidence, my lord. I think custodial detention may not be required, my lord.
I will keep legislative question. I am going on that list of partnership. Otherwise, the petitioner has appeared and her statement is also recorded. But if I go by the basic lawsuit, then there are documents are there. What I want to state was in the FIR lawsuit, it is lodged by another regional manager. So he has the knowledge. He has the knowledge and all the authority of the documents. And in his statement, he has stated that he has stated something like this. And according to him, the petitioner along with his field officer, Satyendra Kumar Pathak, he has some tempered with some documents, which is as consolidated consumer credit report, which has to be generated by the computer of the bank, lordship. It has been manufactured, lordship. And moreover, how they came to know. There is also a story, lordship. They have looked into original system generated, CIC, and another CIC that is false. That is with this loan documents, lordship. So, in my humble submission, I want to state that, lordship, these things have been manufactured, lordship. That has to be done by the officials, lordship. Because other person don't have access to these documents.
Other person?
Don't have access to these documents.
The
This is generated
field
by-
officer and this manager are the only two persons in the bank.
No, other persons are also there, but they are the higher up, lordship. They are the higher up because he is the bank manager and lordship is the bank manager. And there is also, one thing is also there, lordship. One thing is there called housing loan. To whom these are the beneficiaries are there, lordship, who has got this loan.
The FIR is at page 28. Is that the FIR?
Yes, my lord, the FIR
That is
is
the
page
FIR.
78, my lord.
No, what is page 28?
Page 28. That is my FIR, my lord.
That is your.
I initially lost the FIRs for the same cause of action.
Okay.
And there is a DP also. DP has exonerated me by the bank with a minor penalty, my lord.
Then it is not an exoneration, then some negligence was.
Some minor penalty.
Some negligence may be might have been attributed.
Yes,
to
my lord, the one penalty of minor punishment.
Otherwise, I have
No,
How many FIR?
78, my lord. 78 is the FIR where FIR itself is, my lord, implicated the Satyendra Kumar Pathak, whom he has said that he has done everything, his sign and signature in the FIR that has been implicated against the Satyendra Kumar Pathak, my lord.
66.
And the 66, there is a one more FIR for the same cause of action where I have been granted bail by the trial court itself, my lord, anticipatory bail. Same cause of action.
Your name was perhaps not there.
Minor, yes,
In
I mean, no,
66, your name was not there.
not there.
Yes, sir. Tell us after the interim, and after you have taken down whatever evidence you could, the custodial. Why custody is required? Tell us that. Because she's not yet arrested, and
I have been
whatever
transferred
is
also.
there in the whatever is in the bank, whatever she can do and she cannot do, she's still outside. She has done what she is required to do. Now restraining her or putting her behind bars till the filing of the charge sheet. Any
Otherwise, I have nothing to say on that.
now the allegations we understand there must have been manipulation.
Prima facie, it seems to be established. Only that much I want to record.
Now, for the purpose of investigation, you don't need her.
That they know some other persons.
Ah.
You need to know, and they are also, here also have other more cases, or cases.
Where they have been granted bail, we'll take his word for it.
That means.
By the order dated 14/11/2025. comma, this court had granted an interim protection to the petitioner subject to the following condition. Paragraph 14 to DDO of order dated 14/11/2005. Today, Mr. A.M. Bora, learned senior counsel, assisted by Mr. So-and-so, learned counsel appearing for the petitioner, has submitted that the petitioner has appeared before the investigating authority and her statements have been recorded. Full stop. He therefore submits that there is no necessity for the custodial interrogation of the petitioner as of now. Full stop. The learned PP has submitted that there is prima facie evidence against the petitioner. However, petitioner has still now cooperated with the investigating officer by appearing before him and making her statements and producing whatever documents were and by producing documents. Step. In the facts and circumstances, this court is of the opinion that the interim protection granted to the petitioner by the order dated 14/11/2025 deserves to be made absolute, keeping the terms and conditions as laid out in the said order intact. Stop. Accordingly, the interim protection granted is made absolute. Bill petition stands disposed of.
May it please the court. It's a my lord, anticipated bail application, my lord. My lord, 76 grams of my lord heroin was my lord recovered from one my lord Shiraz Ali and my lord Salma Begum, my lord, while they were coming from my lord Dimapur to my lord for cutting, my lord. And upon interrogation to my lord, the said arrested accused, my lord, they my lord revealed my name, my lord, that the alleged containment was supposed to deliver to the petitioner, my lord. And on that, and for that, my lord, I have filed this application, my lord, and interim was granted, my lord. I have cooperated with the investigation, and my lord, my statement has already been recorded. Otherwise, my lord, nothing has been recovered from my possession, my lord, and the alleged recovery also, my lord, not my lord recovered at the instance of the petitioner, my lord. Only because of the my lord statement of the my lord co-accused person, my lord, I am pending in this case, my lord. Supposed to deliver, my lord. Another case is against the petitioner of
Oh.
Subsequent to the fight.
Your name coming up again and again.
No, Lordship, I got a copy of the order, my lord. Earlier there was a case, my lord, but in that case, my lord, I was discharged, my lord. Lordship.
Why does your name keep popping up? Eh? Why does this petitioner's name keep cropping up in every NDPS case?
Lordship. It's a my lord statement of co-accused, my lord. Otherwise, my lord, since my lord, once petitioner name has been
mobile phone record, political records, that communication yet to be analyzed. Whether any communication made between the petitioner and the vehicle.
He was on interim.
an interim.
He has appeared. CD would not reveal anything against him as of now. As of now. We will make the interim absolute, giving you the liberty to bring to notice of the court any further materials, if found against him, which may require a relook. Because on the other case that the CD refers to,
yes,
he appears to be discharged.
I mean, this case, FSL is also positive.
Here in this case, Upon consideration of the police report, including the statement of the witnesses, and after hearing both the side, court finds the charge against the accused is groundless. What do they call in Assamese? Khial. Yes. But Mr. So-and-so learned counsel appearing for the petitioner also heard Mr. Goswami learned counsel appearing for the learned additional PP for the state. By the order dated 25/11/2025, this court had granted an interim pre-arrest bail to the petitioner, subject to the following conditions. Full stop. Subject to following conditions. A condition in the DDBO. The learned counsel for the petitioner has submitted today that the petitioner has appeared before the investigating officer and his statement has been recorded. Full stop. The learned APP has submitted that the petitioner has been found to be involved in other cases involving the NDPS Act, where the case has been charge sheeted, to which the learned counsel for the petitioner submits that in special P in case number special within bracket P 31 of 2024 on a special NDPS case 31 of 2024, though the petitioner was put up as an accused, the learned trial court had discharged the petitioner. Full stop. Having considered all the materials on record, this court is of the opinion that the interim bail granted on 25/11/2025 in so far as it relates to the petitioner deserves to be made absolute, subject to the condition that the state would be at liberty to bring to the notice of this court any further materials collected during the investigation to implicate the petitioner. Accordingly, the bail petition is disposed of. Bring it to our notice that we have got this CDR. We'll reconsider it.
My lordship. In this case, lordship. In this case, co-accused has already been granted bail, lordship. At page, lordship, 21, lordship. Co-accused has already bail, lordship. And lordship,
What happened?
Page 15, lordship.
Why is he apprehending arrest? Tell us that. What did he do?
Lordship, there is a more violence, lordship.
I
have stated in paragraph, lordship, paragraph 4, page 5, lordship. I'll tell you what happened.
Your name is Nadeem?
Yes, sir.
You are Salif.
Oh, yes.
I know Mr. Sharma.
Salim Ahmed, I'm sorry, no.
I know Mr. Sharma.
Actually, lordship, this petitioner, lordship, the rapid card driver, lordship. I have annexed identity card also. And the date of occurrence, lordship, he is in Guwahati, lordship. So completely a false story, lordship, was initiated in the FIR, lordship. Full and concrete story, lordship. Going for the injury report, lordship, was grievous by start to by injury report, grievous and start by start tokens. Except concern, it was one of them.
They were arrested on the spot or later, or he's
Not
apprehending
arrested.
arrest. Sorry.
In fact, lordship, earlier in India, earlier case, lordship, with petitioner elder brother and nephew, lordship, is there. they have already granted me pre-arrest bail.
Which people?
An earlier order, Lordship,
Ah.
where anticipated bail was granted,
Ah.
Lordship, my elder brother and nephew, Lordship,
Ah,
was there, Lordship. They have been granted bail, Lordship.
this page 21.
Page 21, Lordship.
So as a family, you have gone there to attack someone.
Oh, Lordship, that is not the case, Lordship.
Eh?
That is not the case, Lordship. The family, Lordship, actually, Lordship, 200
We thought that
villagers,
happened only in the movies.
more than
The whole family attacking someone.
more
Yes,
than
what
200
does the
villagers,
CBC?
Lordship, they gathered, Lordship. Subsequently, this is not-
Brother and nephew granted pre-arrest bail. There is an observation also. Story narrated in the FIR may not be the actual story. Huh?
Any condition, Lordship, I will cooperate to investigation, Lordship. Any condition, Lordship, any stringent condition, Lordship.
Bill allegation against Masiru Ali. Witness like you co-accused. But he was, the petitioner was one of them. And now with Masiru Ali, they were there also affected. Physical assault of person. And the injury reports say that these are previous installed by third person.
In fact, Lordship, there are 200 villagers, Lordship. How can they identify myself, Lordship? 200 villagers, they gathered together, Lordship. In the paragraph I have stated.
Why? Why is this man so bad? We are granting the bill. Heard Mr. Sharma learned counsel appearing for the petition. Also heard Mr. Goswami learned counsel appearing for the learned APP. Full stop. The case diary as called for has been received. The learned counsel for the petitioner has submitted that this in a case arising out of the same FIR, at least 6 of his co-accused have been granted the privilege of pre-arrest bail by this court. Full stop. On a perusal of the case diary and of the statements made in the petition, this court is of the opinion that the petitioner can be granted the privilege of a pre-arrest bail. Full stop. Accordingly, this court finds that the petitioner, or this court directs that the petitioner, in the event of their arrest, may be released on furnishing page 23 not facility mark A be disposed of.
Obliged.
Item 26.
None appears for the petitioner on, What is the allegation regarding?
51B case. Offense of their completed.
None appears for the petitioner on call.
Shortfall was there.
That's it. What?
Will appear, my lord.
You'll approach the trial court.
Yes.
The heard Mr. Swenson counsel appearing for the petitioner. The learned APP has submitted that the charge sheet has been submitted by
CS number 01 of 20 dated 17/1/26.
Stop learned counsel for the petitioner. Praise that he may be allowed the liberty to approach the learned trial court to pray for regular bail. Stop. In view of the submission, this bail application is closed, allowing the petitioner to approach the appropriate trial court to pray for regular bail.
Highly obliged.
We have received the case diary.
Yes. Yeah, please, my lord. My lord, I'm interim, my lord. I'm on interim, my lord, and this petitioner, my lord, statements recorded, my lord.
Huh. Heard Mr. So-and-so learned counsel appearing for the petitioner, the learned APP submits that the case diary is yet awaited. List the matter again on 522026. Awaiting the case diary, full stop. Interim protection granted earlier shall continue.
Deeply obliged.
Is also same pair, 16 of it, is an interim.
Same order, same parties. No. 522026. AHCD
36.
37.
36, same order,
Deeply
same order.
obliged.
Along with postmortem report.
PM report not received yet. 103.
Ah.
103.
The murder.
Why do you anticipate an arrest? Why do you?
Because we are named in the FIR. We are named, we are relative and we are neighbors. Let the PM report come to ascertain the cause of death. Body.
It is submitted by the learned APP that the PM report is yet awaited, full stop. You are appearing for?
And put the report in that.
Okay, Mr. So-and-so appears for the petitioner, Mr. So-and-so appears for the informant. Yes. How did you know that these people have,
But I have the,
you have named them? How did you know?
the informant is the son of the deceased.
Huh?
And but why?
The deceased was killed on the road.
Why his father was killed within a distance from the house. They got the, they got the information that, even prior going on, immediately they have come and they have seen. That's the Kazi brother. Kazi brother is deceased. And
List again on
6 to 26.
6 to 26, awaiting the postmortem report.
Much obliged, Your Lord.
This matter relates to the love affairs between a boy and girl. And both were missing one day, my lord.
Eh?
Both were missing one day, boy and girl. The family of both the parties, my lord, knows about this fact, my lord. Subsequently, after 2 days, the both were again arrived at home, my lord. Both my girls and boy both returned to home, my lord. So, my lord, since in 87 section 87 a case was registered on missing. So this case now, my lord.
Who is he?
You
are the boy who ran away.
I am the boy, my lord. Now, since case is registered, my lord, so I am in apprehension that.
My daughter, 15 years.
15 years, 11 months, and 15 days. And it is, my lord, kindly see that both there is a communication between both the father of boy as grandmother. Went to school but did not, I and my family, after doing ample effort, is able to know that one Zabir Hussain, son of so-and-so, kidnapped my daughter and taken away. On knowing the incident, I immediately approached his father, Manazir Ali. He assured me that upon rescued his daughter, he handed over daughter over my family. Unfortunately, after passing 12 hours, father of the son informed me that he failed to trace out his son. But subsequently, my lord, he able to get his son, my lord. It is absolutely a love relationship, my lord. It is absolutely a love relationship, nothing else, my lord. Even both the parents know there was that fact. Both boys and girls appeared, my lord, after 1 day. Both boy and girls appeared.
What is the age of the boy?
Age of the boy, 24 years.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP who has produced the case diary, full stop. On a perusal of the materials available on record and on a perusal of the
My lord,
materials available on the, yes.
this, girls is recovered, record is there, my.
So,
She did not state it against me anything, my.
how did you know?
Because my lord, I have applied, my lord, certified copy, then.
You got the statement of the girl?
No, my lord. I have appeared because the IO has submitted, IO has produced the girl before the superintendent civil hospital regarding these issues, my lord. So whether anything is done, this certificate could be I have, my lord.
So that gives you the privilege of.
So my lord, nothing regarding sexual assault or anything is there in this case, my lord. Nothing, my lord.
Is that so?
Yes, my lord.
A 24-year-old boy running away with 15-year-old girl.
16, my lord, this is not regarding kidnapping or something, my lord.
Having produced the materials on record and the statement of the victim, of the alleged victim, as available in the case diary, this court deems it a case which is fit for grant of the privilege of pre-arrest bail. Accordingly, it is directed that the petitioner, in the event of the arrest, the petitioner shall be released on a
20,000.
punishing a bond of rupees.
20,000.
Huh?
20,000.
20,000. 20,000. With two sureties of the like amount.
My.
Subject to the following conditions. Until she is 18 now, don't go again. Huh?
Fine, God bless.
Yes, dear. AB disposed of. What is this? What is this IA for? 20 days.
Yes.
Huh? What is the merit in the petition? If there is any merit, let us wait. If there is nothing there, non-appears will decide it. Same. Okay, heavy. Okay, order, last order.
Yeah, please, your lordship. I have checked as per office note 24/10/25, my lord. The respondent number 2 has been received through IO, my lord. Service has been completed, my lord. And as per my lord, even record has been received, my lord.
Record is also received.
My lord. So, need to appoint an amicus curiae, my lord. Perhaps.
Service completed.
I was completely 24/10. The office note.
What can be your general grounds for the appeal? Just an overview.
Grounds I have not checked, my lord, because
Hmm?
morning I have checked that. office note.
We expect more than that of you.
I'm sorry, my lord.
Huh?
I thought today only amicus will be appointed, my lord.
5 years.
Huh?
5 years. 5 years.
You say notice has been received, has been served.
Yes, my lord. On
From
20
where?
there is a office number 25/10, my lord. 25.
2410.
24/10.
Notice has been issued through so and so.
Yes.
Notice has been issued. Where is the receipt?
Through OC, my lord, to respond number 2, my lord.
No, it has been issued.
Issued.
Has it been served? Can we take that to be served?
my lord.
Issued and served?
But if it's served in copy of the
That is a long bag, my lord, on 10th, my lord. That's why I was thinking.
Eh?
Long bag on 24/10.
Can
24/10, my lord.
Can you take a look?
Uh.
Tell us. I cannot trace out that it has been served. Deduction. Side next to my deduction. Unless served, we would not like to appoint anyone.
Yes, yes.
Yes, sir.
Also,
Yes. Yes, sir.
Let us start at 2 p.m. Mother, it is already,
Uh-huh.
it is already 1 p.m. Let us start at 2 p.m.
Oh, yes. At 2.
At 2.
Any proof of service? একটু 2টা বজাত ল'ম আৰু hearing কেইটা। নাই 2টা বজাত ল'ম আৰু hearing কেইটা।
2 p.m. my lord, 48 to 2 p.m. But he will calculate it.
No. Yes. Anything? No, office notice issued. Oh. Yeah. This same is forwarded to the learned APP. Then what happened? Did it reached? If it has been received, we'll appoint an amicus curiae, fix it for hearing.
my lord. That can
If
be
not
done.
received, we'll request you again. Thank you.
Tip level.
item 1 is on 170 days and item 20 is on 180 days.
In item 28, your lordship.
Item 28.
Yes.
Okay.
Herein I sought bail, your lordship, on the ground that the section 47, although it was complied, it was not complied as per direction of the Honorable FX Court.
Where
Herein
is
the
that
petitioner, they are the illiterate person.
So now the format has also to include that 47 notice format has to include language in which the
Yes.
notice is requested to be served. If illiterate, voice recording to be sent.
Yes, yes.
No.
Nothing, your lordship.
No, I'm
No,
just
no,
asking. For
in-
illiterate person, should it be voice recording now?
No, voice recording, that is not there, your lordship, but in the language in which he can understand, your lordship. But herein all the petitioner, they are the illiterate person. Lordship,
Did you
kindly,
inform the police that they are illiterate person and they do not understand this language?
page 18 onwards, your lordship, these are the notice of 47.
I understand. Where is your information to the police that they are illiterate?
But petition number 3, your lordship, he put the thumb impression here.
What is his name?
Page 22, your lordship. Page 22. This is in respect of petition number 3.
What do you say to that?
Lordship, in this regard, your lordship, I. In para 5 of my petition, I have made a statement that they do not know how to read and write English, your lordship.
that you are saying before this court that you do not know how to read and write.
I have made a statement in my petition also, Your Lordship.
Yes. Now, did you say so before the
No.
remand magistrate that I don't understand what is being done, I am illiterate?
Your Lordship, the arrest is illegal, Your Lordship. I think it would not be appropriate, Your Lordship, for remanding back the matter before the.
I understand. That is what we are trying to find out, whether it is.
And that about also, Your
Legal.
Lordship, in item 28, Your Lordship, my friend has submitted that 180 days they have filed. But if it was filed 116, then it will be 181 days, I think. Right?
Is it 180 or 181? Huh?
In the judgment, Your Lordship, in 56(4), Your Lordship, that has, in this judgment, Your Lordship, 56(4), Your Lordship, it has para 56, Your Lordship, kindly. Number 2.
Understand.
And 4, Your Lordship, says that if it was not in terms of this, then the arrest will be.
We understand that you did not understand the grounds of arrest given to you because of the language. Did you inform the trial court that I do not understand English? I don't know what is my ground of arrest?
I think Your Lordship, Your Lordship
Since
also
you are-
can.
Since we are going purely on a technical term, we are going on a technical basis purely.
Therefore, only I am saying, Your Lordship, this code is also can entertain that issue, Your Lordship. I am on technical ground, Your Lordship.
Therefore, the technicality, whether you had taken it up as the first ground. Did you tell the court? 180 days, he says.
But in terms of.
Yes, in the language that they understand. Two of them we understand. Standing in English. What about the thumb impression person?
But in para 5 of my petition, Your Lordship, I have written it. Not only the petition number 3, 1 and 2 also. The basic reason of serving notice, Your Lordship, is to make understand that person so that he can take recourse, Your Lordship.
So we have to go to the case diary and expect what. So then you appear before the trial court. And for the trial court.
It was in your trolley bags.
I am not on that, Your Lordship. I am only on 57, Your Lordship. Oh, sorry, 47. Although the 47, it was complied, but not in accordance with this.
Is here to ascend you. When the Supreme Court judgment says that it has to be done in a language which he understands. Supreme Court also says that it has to be, the burden would be upon the arresting authority to show that there was total compliance. When there is no statement here in the notices to say that at page 17, you see the grounds of arrest were explained to the accused in writing. He says, I don't understand English. You give it to him in SMS, he'll say, I don't understand SMS. This is not only for this case, we are trying to find out because something we say will be followed.
But in fact,
If
your
not a
lordship,
seal, huh?
in fact, your lordship, in
We are
paragraph,
not very convinced only for the reason because you did not take up this ground before the remand magistrate to say that I don't understand what is happening to me, sir. Getting my point? I don't know why I am here. You did not do it then.
I understand, your lordship. But what
Then someone with knowledge of
what I'm saying, your
56,
lordship,
3, 1, 2, 3, 4 comes in.
but what I'm submitting is that, your lordship, if arrest was not in accordance with this,
Ah.
your lordship, then in that case, your lordship also can pass appropriate decision.
If you insist on only repeating one line that you are saying, then we can simply hold that there is nothing on record to show that you did not understand English. In fact, your signatures being in English, we have to reject that ground.
Then lordship can call for the record, your lordship.
Which record?
If recovery is conscious present from the petitioner, then what?
The regards
No,
will come in.
recovery is not sufficient, your lordship. It may be from, I'm not saying on that. I am only saying that if the notice was served, then whether this notice was in accordance with the law laid down by the Honorable Apex Court.
So
That fact,
the
your
first time that you did not understand the notice was when? When it was served upon you?
Yes,
When was the first opportunity to say so?
I have met
When
category,
was the first opportunity to say so?
the first opportunity, your
To
lordship.
say so was before the remand magistrate.
But
Sir,
if-
I don't know what is happening. Is the first sentence.
These are the illiterate person, your lordship. The circumstances,
When he was asked, what is your comprehension? Why he was arrested? Then because said that yes, probably engage the council. I have already informed.
Where is that?
Then I have to go to the record then. Yes, submission of that.
ICR has to come. If the petitioner has made a statement before the remand magistrate that I know why I am here,
yes, yes,
we will
Yes.
believe the magistrate not.
yes.
Is it not?
But the question is, lordship,
If the arrest is illegal, then it has to go. I understand that
Yes.
sentence. I understand that sentence very well. We hear it 50 times a day. We are very acquainted with that sentence. In fact, we have set aside arrests when it is illegal.
yes.
But today, if we say that you can take up that ground for the first time before the High Court, give it in Hindi, I don't know Hindi. Give it in English, I don't know English. Give it in Assamese, I don't know Assamese. I'm illiterate. I don't know any of the languages which are written. Then what happens?
Then if your lordship,
It is to be given to you in writing so that they cannot go out of those grounds of arrest. So that you can give it to a lawyer who will understand and try to defend you. Is it not?
yes,
Your understanding the English or not English is not important. You must be told.
Yes.
These are the reasons.
but in
And
fact,
a document which you can give to your lawyer to say, these are my grounds. This is the ground on which I have arrested. That is what we have understood. That is why the writing part or the family part, right? So your being illiterate at this point of time may not convince this court.
but in fact, your lordship, in para 5 of my petition, I have made a statement, your lordship.
You are illiterate.
Blank paper, they have taken signature.
Huh?
Nothing in blank, in fact, in
Oh,
para
then it will be a
5.
fact finding thing. How can we consider that in a bail
Therefore, only, your lordship, I'm saying, record may be called for,
petition?
your lordship.
That we can do. And we can see what the remand magistrate had asked. One of the matters we have said that the remand magistrate has not made any inquiry on that part. And therefore, the arrest may not be, that therefore we went by the petitioner's version. Because the question was not even asked. In both the cases, heard Mr. M. Khan led counsel for the petitioner, also heard Mr. D.P. Goswami led additional PP appearing for the state. Huh? The call for the, huh?
Item number 1.
Ah,
It's not praying for that. It's prayer for only one. Item 28, item 28, item number 3.
item number 1, are you taking that ground?
Yes,
What is the
item
ground in
number
item
1, your
number-
lordship, that plea I have not taken.
Huh?
In item number 1, that has not been taken, your lordship.
You want to approach the trial court, you want us to go to the records and decide this also?
Okay, in item number 1, your lordship can I will approach before the court below, Your Lordship, no problem.
You are, there were 3 persons arrested, na?
Yes.
Item number 28 contains how many? 3. Then who is this?
In item one, Your Lordship, nothing was recovered from his possession and on the basis of the statement of the item number, petition of the item number, he was arrested.
Okay, in item number 1, the learned counsel, the learned APP has submitted that the charge sheet has been submitted, and in such view of the matter, the learned counsel for the Mr. A.M. Khan, learned counsel for the petitioner, has submitted that he may be allowed to approach the learned trial court to pay for regular bail. Stop. Prayer is allowed. This bail petition, bail application is closed, allowing the petitioner to approach the learned trial court for approach the learned trial court seeking regular bail.
Lordship can maybe reflect the date of filing the charge sheet, Your Lordship.
That learned APP has submitted that the charge sheet has been filed in the matter by charge sheet number
01/26.
01/26 dated 16/1/2026. And in item number 28, you write down, heard Mr. A.M. Khan, counsel for the petitioner, and also heard Mr. D.P. Goswami, learned APP appearing for the state. Upon hearing the learned counsel for the parties, it is deemed appropriate that the scanned copy of the trial court records be called for. So accordingly call for the scanned copy of the records of the learned trial court. List this matter again on the 6th of February 2026 for further consideration. Yes, sir. You have gone through PAMIDI. Then there is another order at page 70. No. Not page 70. We'll come to you, Mr. Mahajan. Just let me get some clarifications from
Yes,
you
yes.
first. Page 62, middle of the paragraph. Since communication to the parents of the petitioner is not revealed. Oh, page 61. Page 61, I have heard the learned counsel 1, 2, 3, 4, 5, 6. 7th line from the top writing starts with writing in language. Okay. It is also settled position of law that communicating would ultimately be accepted only when the person on the other end comes to know about the same. Otherwise, communication is not complete. Now, in your this thing, in this petition itself, that 48. If you come to 48, where was that page number?
57.
Yes, 56. You see, one received something 1345 hours. You find in the middle there is a signature on the black part. Officer in charge, Basari Chera police station signature, just near the received 1340. Let us assume for the time being that it is the Rewari. Printout of whatever was sent to them, it's a printout of that. At 1345 he receives. The production is before 4 o'clock. 15 minutes service, 2 hours prior to the production, again gone. Even if we assume that this is Rewari. Then when you give the grounds of arrest, what are the grounds given? During search of the vehicle, 3,000 number of bottle of codeine is found. Later after the seizure procedure, complainant 57 I am reading, along with accompanied staff and apprehended accused.
Yes.
Ground of arrest. From the interrogation statement of Mohammed Rais revealed that seized consignment was being loaded from the godown.
Yes.
Now, the other recovery that you said was made from the premises. hidden behind that wall, in Polton, where is it?
It is not there even in the forwarding report, my lord.
Where is it? So the ground of arrest is incomplete. If you want to press on that, then this ground of arrest is incomplete. He did not have the full knowledge of all the grounds of arrest. He was not told that we have recovered something from your godown. Then what happens?
Consider on the backside of the receipt.
That part is not there. He was not told that we have recovered material from behind your office. That is why we are arresting you. Is it not?
Yeah.
And under similar circumstances, people have been, because the consignment was consignment, it was simply being that he was involved in opening that thing, putting it inside. Nothing. No statement to that effect. From where is the petitioner? Haryana.
Haryana.
We'll put in some stringent condition, but otherwise we find notices were not sufficient. Yes, Mr. Mahajan, what do you say?
My lord, exactly, my
To
lord.
supplement.
To supplement, my lord. But in the first case, my lord, this is academic, just nothing to do with this, my lord. Now, because of all these authorities, my lord, a bounden duty has come on the magistrate. That is not there in the statute, my lord.
And
Whether
he has to find out.
47, my lord, regarding 47, he is to ask whether the contents you understand or not. It is a bounden duty that has to be incorporated somewhere in the statute on a subsequent date. But that down there has to be an authority of yours or the apex court, my lord.
But then if that is not being done, the complete discharge of judicial duty will not be there.
Exactly, my lord. Because
Every
of this,
case where we would like to either dismiss or allow, we are still taking time.
that's
Then we can
regarding
brush all
that
this
case, my
aside.
lord. There regarding that case came up, my lord, and not understanding the language, my lord. Just prior to this, my lord. There the magistrate is
In one
bound to
case,
us-
we have found little time ago, scene 47 notice, 48 notice, this. Record does not contain the 47 notice.
my lord.
Scan copy does not contain the 47 notice, 48 notice.
Oh no, my lord, no, yeah, I have
And another case,
my lord.
some time ago, we have asked the trial court to clarify.
Yes, my lord. My lord, the Lordship,
Where it has come.
Lordship Authority, my lord, that para 13 and 14, it speaks volumes, my lord. Parameter.
Jahan's order is also
Pamidi, my lord.
Pamidi that we
Lordship,
only touched.
Pamidi Anand, my lord. That's your Lordship's order.
Huh?
13 and 14, my lord. It speaks everything, my lord.
Here also, in the other case also, this has
It
been.
should be, my lord, in black and white, possibly, my lord. This is necessary, my lord. My lord, whatever is there in the article, my lord, constitution at the top, my lord. Thereafter the statute, my lord. So regarding service of notice on family members, relatives, have I made my, as I have understood, my lord, that 48(3) is bound to be complied with, because in no thana, possibly, my lord, 48(3) booklet is there, my lord. That has to be there, my lord. Otherwise, what will happen, my lord? They will incorporate it in the case diary as my lord, afterthought, my lord, which may not be in consonant with truth, my lord.
Perhaps the learned APP has been told in the morning that we do not follow it up after we send the WT message.
Exactly, my lord. Now, my lord, what has happened in this case? In Mihir Rajesh, para 47, it is there, my lord. Exactly, lordship's point.
If you're in your petition page 62, this court has observed.
Exactly, my lord.
48(3).
And here
Yes.
the days are 3 months. Exactly, my lord, with all respect, my lord. 3 months, 4 days, my lord. No stay. WT message sent. No action taken. And the dates are, my lord, with all respect, my lord, not to talk of 2 hours. 3 months, 4 days, my lord, till today.
Technically. You need to consolidate all the different orders of this court, make out a format.
My lord.
Then this technicality will go, otherwise the technicality will remain. to the discomfort of the prosecuting agency.
Prosecuting.
To your discomfort.
Why?
You're allowing it. Strangers, because he's from outside. It will be, we are not thinking about the amount now, but one of the persons has to be a government servant, either from the state or the central services. One of
Central
the,
services.
either the state or central.
Oh, my
services.
lord.
One government servant has
Yes,
to be there.
Yes, has to be.
One government servant
Yes.
has to be there and not to leave the jurisdiction without furnishing all details before
My
the session judge to
My
his satisfaction.
My lord. Session Judge Sri Bhumi, my lord.
Disposed of allowed.
Highly obliged, my lord.
You'll have it tomorrow.
My lord, my lord. Obliged, my lord.
Disposed of. ৰাতিপুৱা আপলোড কৰিব পাৰিব গধূলি লিখি দিম এইটো থৈ দিম তাতে আজি ডিসপোজ অফ কাইলৈ ৰাতিপুৱা আপলোড হৈ যাব গধূলি লিখি দিম
Being again, item 42.
Office note dated 9/1/2026 reflects that service report is not complete. So placed again on 3rd of February 2026 with service report. Both the cases. Both the cases. দুটা আছিল না possible? কিমান? 43 and 42 and 40.
Okay, 45. 45.
People was about to bring inspection, my lord, regarding 40. I think.
Regarding the service of
Yes, my lord.
notice on the respondent number 2. Let us wait for some more time. Let the report.
Obviously.
Otherwise, we'll appoint an, if the service is complete, we'll appoint an amicus and proceed next week.
Please, my lord. In the appeal against the convictions recorded by Lana edition of section also case court, convicting the accused appellant under section 304 part 2, awarding conviction of the sentence of 3 years imprisonment and the clear fine of rupees 15,000 in default to undergo imprisonment for under 1. So the judgment has been assailed on several grounds. The first one, the occurrence took place in 2001. 17/1/2005, my lord. The 3 accusers are originally the marketers took place between the accused and the deceased and his son. This is Khogeshwar. This is Khogeshwar Nath and his son Jayendra Nath, my lord. So the police has submitted charge sheet under section 376. Section 376, 326. 376, 324, etc. Ultimately, after 2 days of the occurrence, after 2 days of the occurrence, accused died in the hospital, my lord. Accused injured Khogeshwar Das died in the hospital, my lord. So police has made a PR to 302 IPC, and subsequently 302 IPC was added, and the charge sheet was submitted against the 3 accused. 3 accused, namely, my lord. 3 accused, Homeshwar Nath, alias Saur Nath, and the Probin Nath and Midul Nath, 3 accused, my lord. The Lana Trial Court, the additional session judge receiving the case on committal, has framed charge under section against the 3 accused under section 302 IPC without framing any charge under section 34, my lord. So my first, this charge is defective, my lord. When there is more than 1, less than 5,
there is a common intention among the accused. The search should be framed under section 302/34 of the IPC. So my first assumption is search is defective, my lord. When the search is defective, conviction recorded against the accused person is also defective, my lord. The second submission, my lord, there were three accused on the same set of evidence, two were acquitted, my lord. The Probin Nath and Midul Nath, they were acquitted. I read out the evidence. Lana trial court relied upon the evidence of the witness PW4, PW7, and PW8. I read out it. All the witnesses have stated, on the other, Lana trial court have submitted there, recorded that there is no eyewitness to the occurrence, my lord. She has recorded the conviction on the basis of the circumstantial evidence, my lord. So if there is circumstantial evidence, there is no direct link between the accused and the crime committed, because none of the accused has stated that this accused has assaulted or this accused has not assaulted, because three accused, my lord. So among the three, Lana trial court has recorded his finding on the basis of the PW4, PW7, and PW8, my lord. I will read out the evidence of the PW7 as reflected by the Lana trial court in her judgment.
What is the name of the deceased?
This is Khorgeshwar Nath, my lord. Khorgeshwar Nath, the son of Bhadrabda Jayanto Nath, PW8, my lord. So I'd like to read out the evidence of the PW8 first, my lord. As per record, PW8, this is Khorgeshwar Nath, PW8, my lord. This is I am reading from the certified copy of the evidence, my lord. The originals are not record. I read out. This is Khorgeshwar Nath was my father. The occurrence took place about 6-7 years ago at about 7 p.m. My brother Jayanta Nath and one Homeshwar Nath had a quarrel. Originally, quarrel took place with brother and one Jayanta Nath, Homeshwar Nath, my lord. They had quarrel in the Sapori. Homeshwar Nath thereafter returned home and was waiting on the road in front of his house with a lathi in his hand, who also told that he would quarrel in the they have quarrel in the Sapori. Thereafter, the Gauvira Someshwar informed my father. My father is the deceased. Homeshwar was waiting in front of his house with a lathi in hand to assault my brother Jayanto. Then I, with a torch in hand, came towards Homeshwar to what had happened. I asked Homeshwar who was assaulted, and at the time found Pediram Nath and Midul standing there at that time.
There is some confessional statement also. There is some confessional statement. PW12.
It is sheep.
At page 9 of the judgment, para 20.
Page 9.
They refer to some confessional statement before the magistrate.
Pagination is wrongly issue, PW8. I'm reading about PW8, page 12 in the judgment, evidence of PW8. Page 12. Should I read out this? PW8, Muninda Nath, in his deposition, gave the same evidence as PW7 and stated that this was his father and occurrence took place at about 7 p.m. He stated that his brother Jayendra Nath and Homeshwar Nath had a quarrel in the Sapori sometimes prior to the incident. Homeshwar Nath thereafter returned home and was standing in front of the house with a stick in his hand and told about the quarrel in the Sapori. Thereafter, the Gaungura Someswar informed his father that Homeswar was standing in front of his house with a lathi in hand to assault his brother Jayanto. So he went with a torch in his hand towards the Homeswar to inquire what was the incident and at what time he found that Kaliram Nath and Medul Nath standing there. His brother Jayanto Nath along with some other boys were coming back with a Pravin Nath. He came to know that Pravin Nath instigated Homeswar Nath, and then Homeswar gave a lathi blow to his brother Jayanto. It is the assault regarding Jayanto that PW8. Oh, sorry, PW 4-7. Jayanto, son of the deceased, my lord. Not a assault to the deceased, my lord. He tried to separate, but at that time, Pravin Nath with a lathi made a battle Nath gave a blow on the chest of my father. That is the assault was made by the Pravin Nath. That Pravin was acquitted, my lord. Chest of the father. And the lathi was also broken. At that time, Midul again instigated Homeswar and then gave two blows on the head of the deceased Khogen. His father fell down on the ground and injured immediately. He brought his father and took him to the civil hospital. He says that for better treatment, he was shifted his father to GMC Guwahati, but there he was declared dead. In the cross examination, he has stated that prior to the incident in the place, there was another quarrel in the Sapori between Homeswar and his brother. Jayanto, he says that the Homeswar is Jaffa in relation, and he says that the incident of assaulting of his father took place in front of house of Homeswar. Through the quarrel started in his cell, he says that Jayanto came and filed this appeal with some boys, but he cannot say the name of the boys as they belong to some other villages. The Periram, Midul, and the Homeswar belong to the same family, and they are relations. He denied the suggestions that he did not tell the IO that Periram and Midul were standing in front of the house of Homeswar, and Homeswar gave him to death. So his evidence is contradictory. And he also denied this suggestion that he was not assaulted by Homeswar. He also denied the suggestion that he did not tell before the IO that his father came to the place to give him a blow, assaulted Homeswar. He also denied the suggestion that the Pravin assaulted his father on his chest and the lathi of a battle nath there which was broken to pieces, and he denied the suggestion that so his statement evidence is contradictory, because what he has stated before the court was not stated before the IO. So it is not reliable witness further. So the Lana trial court relies on the evidence of PW7, PW8, and PW7 So what PW7 says, my lord? What PW7 says, I read out page 11 of the judgment. PW7 says Kaliram Nath and PW8 says Munindra Nath. Munindra Nath evidence I have already read out. Munindra Nath stated that they are the eyewitnesses and they have narrated the whole incident. PW7 in his deposition stated before the court that about 5 years back at the 11th time of the incident, he was returning from the Sapori carrying props on his on the way. He found Horo, alias Homeswar, and the two, and alias Jayanto, quarreling with each other, and his husband Khogen not to quarrel, but Khogen took the stick from the soldiers, and he also left the place. Subsequently, he heard that Khogen died, so he has not seen on the moment of assaulting Homeswar by assaulting Khogen by Homeswar. So in his cross-examination, he says that Homeswar was instigated and rebuked by Khogen. Khogen Nath, which is next.
What has been established is that there was some quarrel with the son.
Yes.
Homeshwar waited for the son to arrive from somewhere with a lathi. That was the prosecution story. And when he arrived, he dealt a blow to the son of the deceased. Deceased interfered. Scuffle took place. Someone also tried to say kill him or dharma and all that. A stick was taken up. Two strikes to the head and one to the chest. Deceased expired. Defense story is that it was first Khoghen, the deceased, who tried to attack Homeshwar. Heat of the moment, he took the stick and he hit him. And he died. Therefore, the trial court has held that 302 will not come in. 304 will come in because it was in the heat of the moment and the intention to kill may not have been there.
The court has come to a finding that there is no evidence of assaulting by other accused. But here the PWA has stated that the other accused has also assaulted. So it is not certain in whose assault this is the Homeshwar died after. Because it's three person, he assaulted him, he assaulted Doyento, and thereafter the Homeshwar.
The other assaults the court has held to be not proved. There was to some extent, there is a reliance on your confessional statement.
Yes.
Let us see.
Mainly, my lord, trial court relied upon evidence of 4, 7, and 8 only. It is clearly stated in the evidence that the PW 1, 2, 3, 4, 5, 6 has not stated anything. It is mentioned here as my lord. So the seven evidence of PW 7 and 8 I have already read out. The same is the set of the evidence of PW 4. So essentially, it is a criminal case.
Para 31 of the judgment.
Para 31. Para 31 of the judgment. From the above, it is clear that unless an accused admits in crimes, the offense of substantially all the facts which constitute the offense, such statement will not amount to confession. In other words, it is the inculpatory admission, my lord, not the confession. When he narrated the facts, when the accused at the time of giving statement under 164, he has stated the fact what happened. It is called inculpatory admission, not confession, my lord. There is a difference between admission and confession, my lord. So the court has held that it is not.
Para 30.
My lord.
Para 30.
Para 30. Now, a confession statement, the statement differs from admission. The evidence fact does not define confession. State of the defense in digestion, the law of evidence defines confession as an admission made in any time by a person charged. So this is the admission, confession, and.
So he has discussed the difference between admission and confession.
Admission
Keeping the same in view, subpara of para 31, he has said, admitted his guilt, not confessed. So the circumstances which led to the death have been admitted. It is not confessed that I have killed him. There is no such confession. But these are the circumstances under which the entire thing took place.
Admission, accused made admission at the time of his statement under section 313 CRPC. Otherwise, in other way, he has no chance to admit the program. What is admitted before the magistrate, it is not a confession, so it cannot be used against the evidence, by law, against the accused. So what is confessed before him, as per section 164 of the CRPC, by observing all the formalities, then it is the admission, it can be used against him, my lord. But stating of fact that I went there, I met him, so I assault him, he has assaulted me. These are not, it is called inculpatory admission, my lord, not the confession.
And what is the effect of such inculpatory admission?
my lord.
What will be the effect of the inculpatory?
No, it should be corroborated by the other evidence.
Ha.
What the other evidence has stated.
That
Other-
corroboration has come at para
Other-
34.
Corroboration, his statement can be only confessional statement can be used for corroboration purpose. Only for confessional statement. Admission cannot be used for a corroboration purpose, my lord. So actually, practically, and word admission is used in case of civil proceeding, my lord. In civil case, what the plaintiff or the defendant has admitted.
Moment you say inculpatory,
It is
the
admission.
moment you say inculpatory,
Inculpatory-
culpable is punishment. So inculpatory will
inculpatory
relate to
admission-
criminal law, not to civil law.
It is in term of inculpatory admission, and it is not the confession, my lord. So here is no confession. Actually, here is no confession of the accused, my lord. Actually, what is stated by the other evidence here, it should be corroborated strictly because in a criminal case, it should be beyond all reasonable doubt. Sufficient presumption, however strong it may be, cannot take the place of proof. Proof is one thing, suspicion is another thing. It is quite different, my lord. So the suspicion presumption cannot take the place of proof. It should be proved beyond all the reasonable doubts, my lord. So it is not proved beyond reasonable doubts that it is Homesor who has assaulted Khogeshwar as a result of assault he died, my lord. There is no evidence to that extent.
Any
No,
of the
no.
witness, has any of the witnesses stated that someone else also assaulted him?
He witness, your lord,
Who has said that?
Only court has relied upon few witnesses. PW 4,
Huh.
PW 7, PW 4, PW 7 and PW 8, my lord. But what PW 4 has stated, para 12 of the judgment, my lord, para 12. It is seen from the evidence that PW 1, 2, 5, 6 do not know anything about the occurrence. PW 1, Srimati Putu Devi simply stated that she heard that Khoghen Nath was killed by the accused person and police. This hearsay, and they call her and took this signature. Similarly, is the evidence of PW 2 Bhaskar Bora.
PW 4 is at para 13.
PW 4
Court has said he is an eyewitness to the altercation only.
PW 4 evidence para 13, my lord. Para 13 may be seen. The PW 4 Sri Rishi Bora is a witness who has stated that on the day he was coming from Sapori, and he saw many people gathered, and there was an altercation between Homeswar Nath and British Khoghen. As he had his couch with him, he came home and took his bath, and then he came to know that this is Khoghen Nath was being taken to the hospital, and he was injured. He also heard that he has not seen. He is the hearsay, my lord. He has heard that later on Khoghen Nath was taken to Guwahati and he died. He also deposed in his cross-examination there. He later on came to know that Homeswar Nath has killed the Khoghen Nath. So this was also taken. Cannot say how this was killed and how whom he was. He is an eyewitness of. As he is an eyewitness to the altercation only. Heard on the altercation, my lord.
So 4 we discard.
He ended
4 we discard. We will discard 4. We will not rely on 4.
If it discards,
Huh.
it will be 7 and 8 is a similar.
Yes. What does 7 say?
It will be 7, I will come.
Seven, we are not interested. Please come to 8. 8. Para 16.
Para 6. 16. It will be 8, huh?
16. Page 6 of the order.
Para 16, page 8. PW 8.
Huh?
Munindranath, PW 8, Munindranath in his deposition gave the same evidence as PW 7 and stated that this was his father and the occurrence took place at about 7 p.m.
he stated that his brother Jayanta Nath and Homeswar Nath had a quarrel in the Sapori. Something prior to the occurrence, that is prior to this offense, Sapori. Homeswar Nath thereafter returned home and was standing in front of his house and speech in hand and also told about the quarrel in the Sapori. Thereafter, Gaungura somehow informed his father that Homeswar was standing in front of the house and with a lathi in his hand to assault his brother Jayanta, not to assault the deceased, but his son Jayanta. So he went with a torch in the hand and Homeswar to inquire what was incident and at that time he found that Teliram and Midul Nath standing there. His brother Jayanta Nath also with some other boys who were coming back with the Praveen. He came to know that the Praveen instigated Homeswar with his instigated Homeswar Nath, and then Homeswar Nath gave a lathi blow to his Jayanta, not to this my lord. He also stated that Homeswar also assaulted him on his hand and soldiers. The hangman soldier, if somebody assaulted a hangman soldier, then he would not die, my lord. He tried to separate them, but at that time, Praveen Nath with a lathi made of betel nut, he gave a blow on the chest of this father. Then the lathi was also broken. At that time, Midul again instigated Homeswar and then gave two blows of the head of this, and this is Khoghan. His father fell down on the ground immediately, and he brought his father into civil hospital. This is being his cows and that which, and at the time Homeswar reported in that his father assaulted by Jitu Jayanta, and then he would not spare him later on in front of the house of the Homeswar. He saw Homeswar has assaulted Khoghan with a lathi. He asked them to not to quarrel with his daughter Khoghan lying with heads. Inquiring into bleeding, immediately Khoghan was taken to the civil hospital. Thereafter, shifted to Guwahati Medical Hospital where he declared dead. So from his evidence, it is not clear that there is huge assault. This is like murder, because others also others are there. When somebody has instigated, he is equally responsible, but he has been given the benefit of acquittal.
His brothers Jayanta Nath along with some other boys were coming back to Praveen Nath. He came to know that Praveen Nath instigated Homeswar Nath, and then Homeswar gave a lathi blow to his brother Jayanta. He also stated that Homeswar assaulted him on his hand and shoulder. He tried to separate them, but at that time Praveen Nath with a lathi made of betel nut tree gave a blow on the chest of his father. Lathi was broken. At that time, Mridul again instigated Homeswar and gave two blows on the head of deceased Khoghan.
But it is not clear that he is assault only. He is assault because this is died, my lord. Because he did not die immediately. He died in the hospital. So it should be clearly an unequivocal proof that at the assault of Homeswar, this is Khoghan died, my lord. Moreover, whatever may be, other two accused were charged in the same set of evidence that they had given acquittal. So he is also entitled to death benefits, my lord. So
because there is nothing here to show that the other accused had ever hit Khoghan, the deceased. They have not hit Khoghan.
Khoghan is deceased.
Huh?
Khoghan deceased.
The other two accused have not hit the deceased. So they are acquitted.
No, Khoghan is the implicate, but the other accused has also instigated.
Huh?
The other accused has given the benefit of acquittal.
No, that instigation, except for
Others are involved.
that instigation part has not been believed by the court because no other witnesses said about the instigation.
But
you have to deny the act.
The Jayanta was assaulted Jayanta, but there is no charge against him about the assaulting of Jayanta. Whole procedural defect is of the trial, my lord. There is no under section 34, my lord.
Now I want to simplify the matter, the shortcut. That is the accused is found guilty under section 304 part second.
Huh?
304 part second, there is no minimum imprisonment has been prescribed. Accused can be convicted by imposing an amount of punishment of imprisonment or with fine or with both, my lord. Here, my lord, the accused has been in jail as of since 2001, my lord.
Eh?
Oh, sorry, his bail on 2001. He was never in, only 1 month he was in jail, my lord. Only 1 month, so that is. he was
Supposing that,
arrested
can we
on-
bring it down to 1 month only?
My lord,
Huh? Someone has died.
he was arrested on, my lord, 12/5/2001.
Huh?
12/5/2001,
Huh?
the accused was arrested. And he was enlarged on bail 22/6/2001. And since then, he is in jail as a matter for last 25 years, my lord.
He is in?
For last 25 years,
He is on bail.
he is on bail. Because the 22/6/2001, in the lower court session record, he was enlarged on bail by the session judge. And thereafter, he was in bail. After awarding conviction, he was not sent to jail, he was allowed to remain on previous bail. And an appeal by the Honorable High Court as High order dated, my lord, it is
Yes.
yes, it is the order dated
He's saying bring it down to 1 month. Conviction upheld, but sentencing
lord.
only 1 month.
last portion, I'm reading.
Ah.
The connected appeal has already been admitted for hearing. It is submitted that the appellant is on bail granted by the learned trial court at the time of awarding imprisonment. The considering entire aspect of the matter and the facts and circumstances of the case and the period of sentence awarded by the learned trial court, I find it fit case to grant the pair. Accordingly, the operation of the impugned sentence is stayed. The petitioner is allowed to remain on previous bail till disposal of the appeal. So since the 2001, he is already on bail. So after under this facts and circumstances set of evidence, my lord, giving benefit of acquittal to 2 other accused on the same set of evidence, it is not proper to convict the accused in the under section 3 of the upon the punishment awarded by the learned trial court. On the contrary, as he was in jail for 1 month, and that period may be treated as punishment, and the fine imposed may be retained, we should be paid to the victim family immediate rights. I think this should be the proper course of action.
Please come again.
My lord.
Please.
My commission, my lord, the case is for 25 years, 2001 case. The accused has been in bail for 25 years till today. Till today he was in bail. So at that circumstances, by upholding the conviction, is sent to the jail. The end of justice should be made. If the period already undergone as UTP, maybe it is a punishment because 3041, 3042, no minimum punishment is imposed, my lord. They may be extended to 10 years, but no minimum is prescribed, my lord. I'll 304. So the may extend to 10 years or with fine alone. Along with fine, he may be convicted or with both, my lord. So in this case, as he has already been in jail for 1 year as UTP, sorry, 1 month as UTP, that may be treated as convictions and the fine imposed may be retained, fine of 15,000 may be retained, and the rest will be paid to the victim family if realized. That is under 304 per second, or imprisonment of either restrictions of a term which may extend to 10 years or with fine or with both. So the may be extended to 10 years, meaning it may be 1 month, 2 days, or 1 day, my lord. So 1 month is there, or by not considering it, by upholding the fine on it, because or with fine. Fine will be 15,000.
only by imposing fine can be disposed, my lord. From the evidence on record is a clear case of evidence because same set of evidence, two accused has been given. So this judgment against him is contradictory in the eyes of law, my lord. So two accused have given benefit and one has been convicted. He cannot succeed in the eyes of law. But my alternate submission that it can be by imposing fine only, he can be convicted. Fine if realized will be paid to the victim payment.
Yes, sir, what do you say?
Subject to correction, I don't have the petition, but what I have heard in witness number 3, there it is clearly stated that first thing he has not on shoulder and hands. He has hit. But on provocation, he has clearly stated on the witness, he has hit on his lord.
No, the hitting on the
His lord.
shoulder.
In the second part,
witness kita পাই যাব। Let us read. You don't have a copy of the appeal? Huh?
No, Lord, it is mistake in the office. It is 2014 please, Lord. It is 2014. So it has been misplaced.
No,
What I have heard, Lordship, in
Appeal is 2014.
Paras, it is in para 16. The hand and shoulder is on Munindranath.
then
No, on the witness. He hits, first he hits Jayanto, then he hits Munindra. At that time when they were trying to separate, as per his statement, Mridul instigated and Humeshwar gave 2 blows to the head of the deceased.
End of the day.
Ha.
That is the point. Then we have to look into the medical report, post-mortem report,
Mm.
where what is the cause of the death.
And
If
so-
it is that, yes, then it will come, that it is the vital part of the body.
Yes, now the trial court has held when the
Court has always stated that there is no intention.
trial court has held, in this case, the evidence discussed above has proved that the accused had no definite intention of causing such bodily injury likely to cause death. So intention was not to cause death. He is liable to be convicted under section 304 part 2 instead of 302.
Five,
Knowledge.
4, Lordship, exception 4.
Ah.
That is the hit of the patient of the-
Yes.
But that is the condition
One
portion
thing is
has
there,
included all.
One thing is there, it is inexplained, it is stated that it is immaterial in such cases which party offers the provocation.
That is different.
That is why Lordship.
One thing is there, a single blow,
The 2 blow I have.
single blow is another thing and 2 blows is another thing.
The trial court has already held that there is no intention. Now the prosecution cannot say that there is
No, I am not talking
intention, but they will have to cross appeal that.
No, no, I am
that
not
admission.
talking about the intent.
Yeah,
I
what
am
is-
talking about,
ah.
it could come under. the
If there is no
exception.
intention, it
I
is
am
to part
talking
2.
about whatever the trial court has got, learned trial court has held a few Lordship. It will come under exception 4. I am also focusing on that point. Why it has come to 4?
Then he said that lower court judgment wrong, then he will have to fight cross appeal, my lord.
No, no, I am not.
Now, the punishment the sentence imposed is 3 years. 2001 incident. 24 years down the line, man has been on bail, has led on his life. Now, if we send him down for 3 years, 3 years again, he will be undoing a lot of things when the intention to kill is not there. Give us some case law where we can reduce the sentence. Get us some case law where we can reduce the sentence.
I am coming on the punishment part, and then the question of because the punishment that is minimum is where minimum is not prescribed.
Huh.
And then your lordship can convict for 1 day, 1 month, 1 year.
Yes.
Extend to 10 years.
When a man dies,
Yes, but.
you will have to
if
convince
not
us to
all-
some extent that we can bring it down to 1 month.
Or with fine only. Or with
In a
fine.
case of that, show us that case law that it can be done in a
It is in the law, my lord. It is in the IPC. IPC Lordship 304 part second, part 2, 304. That is with imprisonment for either description of a term which may extend to 10 years, or with fine, or with both. If the act is done with the knowledge that it is likely to cause death of a man without intention on his part. So trial court has already held that there is no intention on the part of the accused.
We have heard you extensively. We have heard you extensively, and we would like your assisting counsel to put in some labor. Get us a judgment or two where we can bring down the.
Judgment I'll have to start.
And that is what I'm asking
Because
you.
when it is provided in the statute itself, I think the no.
As of now, with whatever records we have and whatever arguments we have heard, 3 years appears to be a reasonable part. To make a shorter sentence reasonable. Give us something. We are agreeing to your proposal.
No. In imposing punishment, your lordship, it is the discretionary power of the court, imposing punishment discretionary power. And by considering the facts and circumstances and evidence on record.
The evidence on record,
all
the
the
facts and
circumstances your lordship will have.
the
to
evidence on
consider.
record, the facts and
Same
circumstances.
set of evidence to accused has been acquitted. Second set of evidence that there is a contradictory prosecution evidence. And third is that the two accuser acquitted and fourthly, he was in bail since 2001. Since 2001, he is in bail till today. In that, considering that aspect also, that is the conduct, this is the conduct. But considering all this aspect, the minimum punishment prescribed by law your lordship may impose. That is the minimum punishment prescribed in 304 part 2. When there is no intention case called under 302, 304 part 2, my lord. The trial court has already held that there is no intention on the part of the accused, my lord.
Okay.
No, it is only because the awarding of punishment is the discretionary power of the court.
It is N in 105 in BSN. It is N, and moreover, in the regard to confessional statement, I want to say two things. First is to be, court can
I am submitting only on punishment, my lord, now. The confession here do not come at this stage.
not only two things, Lord. If the confessional statement is voluntary
Ah.
and it is truthful, it seems to be truthful.
Hmm.
And for that lordship to be truthful, it has to be corroborated with other evidences, lordship.
Hmm?
Then it can be taken into action, lordship. It can be convicted on that ground only.
My lord, that
It
part is
not
already gone.
only
The trial,
culpable or
they,
innocent.
without filing cross appeal, the judgment cannot be assailed by the prosecution now. Because he is speaking to the intention on the so and so, because trial court has already held that there is no intention. If they assail in that way, they will have to file a cross appeal, my lord, on the court. Otherwise, they cannot do it.
No, lordship, it can.
Other,
Why not?
wait,
Because it is.
what provision of law?
No, we have.
I am speaking to punishment portion only, my 304 part 2 only. Then what is in the evidence, all have gone.
Not all, lordship, it and which file, not all.
This is a matter of 2014.
Lordship.
304 part 2. Why are we going to the BNA? The IPC then had the provision which may extend to 10 years or with fine. That time it was or with fine. So or with fine, you can bring it down to whatever in the circumstances. Now, a death has occurred, conviction is fine. Having a look at the length of time which has gone, the trial court had also taken into account that it took 13 years to come to a conviction. After the 13 years, he has to spend another 10 years in litigation, carrying the seal of a convicted person. Sentence is state, conviction is not. So can we bring it down?
But they have to.
The conviction will remain. How low can we bring down the sentence in the given facts and circumstances? We were trying to ask him for some case law which shows that yes, given the long trouble that the convict has undergone, the 15 years, 25 years which have passed, now it can be reduced. He's asking us to use our discretion. So he wants us to find out that material. Would you like to find out that material? And this is the code for,
To make charge of the law point.
it is not about the law points, show us something.
Because in coordinate bands also, a few days ago, the conviction was set up only by the period. And I in the.
Show us,
The coordinate
show us,
bands
it's a, due to the long period which this case has taken. Now, sending him to jail may actually prove to be an unjust manner because there was no intention. Just show us that.
Whether by sending the
Sir.
man to the jail at this period,
Ah.
after 25 years of the occurrence, whether any end of justice can be made, my lord. Better if the fine is allowed to be paid, it will go to the victim period, the victim family, my lord. They will do something. What, because perhaps by this time this is died, and after 25 years by sending him to the jail, no substantial justice can be done to the him, my lord.
That is the language we want in from some superior court. These are the words we can rely upon to give you the relief. I can make the search, I can make my own judgment.
Better that is the, when the law provided the alternative, as to punishment, your lordship can do it, my lord. Because or with fine, specifically, or with imprisonment, or with fine, or with both. Imprisonment minimum not mentioned, maximum may extend to 10 years. So 1 month he is in jail, that may be treated as a conviction. And if 15,000 fine imposed, maybe allowed to be detained to be filed with a year.
Heard, Mr. So-and-so, also heard the learned APP. Judgment reserved. Yes.
May it please, your lordship.
Huh?
My lord, notice was served in this case, lordship.
Huh?
Notice was served in this case, lordship.
Huh?
The matter was fixed on 22nd.
Huh?
Lordship, what even, lordship, in the meantime, the petitioner is in custody 60 days as on today. 60 days. On 10th of this month, he felt pain in his stomach.
He
Then
needs
he
that.
was admitted in GMCH. He was diagnosed with acute appendicitis. Doctor suggested to him go to undergo surgery, lordship, because there is no other alternative. But at the time, attendant from family was sought for. That was at about 9.
When can your family be there in the hospital to assist the surgery?
Lordship,
Bail at this point is out of question. You give us a date. We'll tell the jail authorities to have you attend the GMCH 1 day prior, have your test conducted. Someone has to sign
already conducted, lordship. Already.
Someone prior to the surgery, there is again a set of tests which are required to be conducted.
Yes, lordship.
It is not done on the old tests.
Yes, sir.
Is it not? What is your BP on that day? What is your sugar level on that day? What is this? What is that will be seen?
Lordship.
You approach the jail authorities. Who will approach? Who will approach?
Lordship, the family member can approach.
Any of the family member, name one. The father, mother, who?
His wife can approach, lordship.
The wife of the petitioner.
Yes, lordship.
The wife of the petitioner will approach the jail authorities with a date from the GMCH.
Lordship.
Jail authorities will.
What I am on, lordship, after the surgery also, he will be required a care, lordship.
The jail has a hospital.
Jail has a, but he will get sufficient care in his house, lordship. That's my humble submission.
Appendicitis.
Lordship, after operation.
Appendicitis, second day you are released, asked to walk.
That's true, lordship. But after surgery, lordship.
Exactly. They remove it. Second day you are made to stand. Unfortunately, our family has a history of appendicitis. I know a lot of people who have undergone appendicitis operation. With laser, they pull it out at 11 o'clock, 3 o'clock. Please go home. Of course, the jail may not be a proper place where he would be made to do things, but we'll give him some rest in the jail bed,
And that may be directed.
in the
Lordship,
hospital bed.
and the matter may be kept pending, Lordship.
Huh? What do you say? What have you brought on record? Have you brought anything on record? You have mentioned it, but have you brought anything on record?
At the time of filing the petition, there was no.
Mr. So-and-so learned counsel appearing for the petitioner. This matter was mentioned in the morning with a prayer to be listed in the, to be listed at 2 o'clock. Since the learned counsel for the petitioner had submitted that the petitioner is suffering from acute appendicitis
Lordship,
and
second phase,
requires immediate
surgery.
surgical intervention.
Yes.
Will stop. To this effect, the learned counsel for the petitioner, no, accordingly, the matter was listed and the learned counsel for the petitioner has placed before this court the report of the Department of Radiology of the Guwahati Medical College Hospital, where
Last pair, Lordship.
there is, wherein it is noted that the findings are suggestive of appendix measuring 10 mm in diameter as per the advice given by the doctors of the Guwahati Medical College Hospital. Comma. Surgical intervention has been advised. However, on 10/1/2026, the patient had to, or the accused had to refuse to undergo the surgery in the absence of the any family member
Yes, Lordship.
to assist him. Full stop. The learned counsel for the petitioner has submitted that in the event the petitioner is allowed to go on bail only with the purpose of undergoing the surgical procedure, comma, the learned counsel of the petitioner has therefore prayed that the petitioner may be allowed to go on bail, keeping in view the proposed surgical intervention required by him. Full stop. The learned APP has submitted that the petitioner is being afforded all medical facilities during the period of custody, and it was due to the absence of the family members that the surgery had to be, that the surgery could not take place on the proposed date of 10/1/2026. In view of the submission, next paragraph, in view of the submissions made at the bar, this court is of the considered opinion that the ends of justice and medical attention to the accused would be met at this stage if the family member of the petitioner, comma, which may be his wife or his parents, approach the jail authorities to facilitate the surgical procedure required to be undertaken upon the petitioner, and it is provided in case such approach, the jail authorities shall act with promptness and urgency, that this case that the condition of the petitioner deserves to take him to the concerned medical hospital and arrange for the surgical procedure to take place. Full stop. What more do I need to say?
Lordship, matter may be kept pending, Lordship.
Yeah, not this procedure. List again on 22/1/2026. Awaiting service report on the respondent number 2.
Lordship, my learned friend was asked to take instruction whether notice is served.
It is already fixed on 22/1. It will come back again on 22/1. By that date, he will have it.
Lordship, if not served, amicus curiae may be engaged, Lordship.
22/1. It is day after tomorrow,
Day after
sir.
tomorrow, yes, Lordship.
Let him have his day today. Let him have today and tomorrow to find out. Okay. You go and approach him.
Obliged.
Huh? Even matter of 45. Ha. Can be done. Huh. That is what he has undergone 1 year custody during the investigation or the trial, whatever. 25 years. What will happen now giving him? Thank you. Yes, 45 to keep.
Next week also I will take the extraction service of notice. She has been transferred, so.
Yes.
there is nothing easy to communicate.
We'll fix it on 29th.
29th.
Release this matter again on 29th of January 2026, by which time the learned PP assures that the report on the service of notice upon respondent number 2 shall be placed before this court.
Public.
Yuk. See how many. 29 one. এখনই বেলটো লগত থৈ দিবচোন।
This
Yes,
is,
sir.
my lord, this is a case of trapping by the police and the bribery, my lord. And the conviction under 7 section of the PC Act in sentence for a period of 1 year, my lord. That's the case, my lord.
Only 1 year.
Section 7, my lord. Yes.
After all the trap, only 1 year.
Only 1 year, because they could not prove properly. That's the reason, I think, my lord. Because lordship, I'll make my submissions on the point, my lord. The law laid down by this honorable court, as well as the Supreme Court, is that demand and the acceptance of bribe must be proved. Once demand and the taking of bribe is proved, the burden shift on the accused. And then presumption can be drawn under section 20 of the PC Act. That's the law, my lord. Now I will show to lordships, my lord, whether there was demand, it was proved, and the bribe. That's the two things, my lord. So here, lordship will find, my lord, the PW 6. My lord, shall I read the FIR or shall I go to the evidence? Is your lordship pleases, my lord? Because PW 6 is the informant. PW 6, my lord.
We can start with that.
Yes, my let me read that PW 6. In A file, my lord, the evidences are there. In file A, we just checked.
A file can do
A file A.
File.
Two witnesses. One is PW 6, the informant. And along with him, there's another person, my lord, he PW 1. These are the two prosecution witnesses, relevant witnesses. And rest are all, my lord, there are total 10 witnesses. Rest are officials, my lord. One is LDA, one is commissioner, one is assistant commissioner. Those are, my lord. Basically, relevant is PW 6 and 1.
PW 6.
6, my lord. Can I read, my lord? My PW 6, his name is Bhaskar Burman. He lost the, my lord, FIR. In 2004, I had a passenger bus bearing registration number such. To run the passenger bus registration certificate, insurance certificate, pollution certificate, such and such. Road permits are required. If the vehicle is to run within district, the road permit is to be given to the district transport officer. In case of inner district passenger bus, road permit is given by state authority. In 2004, when I wanted to give bus to run under ASTC, I had to obtain consent permit from state transport authority. On 18/4, I made an application to the state transport authority, Houseware Complex, exhibit such and such, my lord. My application was enclosed with the registration such, my lord. Pollution control certificate, fitness certificate is. The application was also enclosed with the letter dated such and such. I handed over application with those documents to the dealing assistant Amor Deka. Here Amor Deka is my lord accused, my lord. Amor Deka,
who told me to come after 2-3 days. After a few days, I went to the office of the accused person who told me that the work was not completed and he asked me to come after a few days. After 4-5 days, I again went to the office of the accused person and he asked to meet his sir to permit for permit and told me that the sir was on leave and asked me to meet him after some days. When I expressed my difficulties in coming to Guwahati from Nalbari for several times before the official, one employee of the said office asked me to pay 3,000 for doing this work, as he has already talked to Amar Deka. My lord, please note down this one employee.
The last few lines we were reading. Before the cross-examination.
Yes.
2, 3, 4,
Before the cross-examination, my lord. Last few lines. Yes, my lord.
some of the line, one of the lines starts at 2:30 p.m.
My lord.
Hmm?
My lord, the pages are same or little.
I don't know the cross.
Anyway, let me do one thing, my lord. Before the cross-examination.
At first, I sought the person whom I met earlier. Can you find that line just above the cross-examination part?
My lord, yes. At first, I sought the person whom I met earlier, but I did not find him. This is that person, an employee above.
Whoever
Yes.
it is, then
Yes.
I met.
I met Amar Deka in his table and told him to accept the money. I kept the money in his table, and after taking the money in his hand, Amar Deka asked me for what purpose the amount was paid. Because probably he doesn't even know. He is referring to other person. Next. In the meantime, anti-corruption people came and arrived such and such. After some time, I was again called by the police officials and see signature on different bodies. Next. My lord, I do not know whether any long. No, let's go.
Cross-examination says Amar Deka did not directly demand money.
That's what, my lord. That's what I'm trying to show. Even both the prosecution witnesses, the independent witness also. I do not know the name of the persons who had come with file in his hand and asked me to give the bribe. Amar Deka did not directly demand money from me for processing the road, such and such. I do not know the name of persons who demanded the bribe amount. When I delivered the amount on the table of Amar Deka, after taking the money, he asked me why money was paid to him. This is what I want to, my lord, say, my lord, because that's why at the beginning I said, my lord, the two parts, my lord. Now, if your lordship kindly see the one, he came with his friend in the office. He's the one, PW1.
PW1.
Yes, yes.
Okay.
My lord, here also, first part, fully nothing is there in chief, my lord. In the cross, he said, what is in the cross in the middle? He says, he signed the seizure list at the time of demonstration. That's the meaning of this entire page. I signed the seizure list which was prepared at the time of demonstration at the inspector office. Then the trial was done in the office.
When you,
Amar Deka and such. He was planning to hear the conversation between the accused and the complainant. Nothing, he heard nothing. I do not know about taking bribe. Lordship will find. Just above cross and the cross, last cross. My lord.
So you say the demand is not proved.
So that's
Once the demand goes, the presumption goes.
That's why, because there is 4-5 judgments I've got to give. Let me give one, my lord. There's no point of give me the last one, 2025. Very recent, my lord. August 25. 12 August 25. Supreme Court Justice Pankaj Mittal. Paragraph 14, my lord. Relevant parties at paragraph 14. A constituted bench of this court in Niraj Datta, Bharat State, has held that for recording a conviction under Section 7 and Section 13 of the Act, prosecution has to prove the demand and acceptance of illegal gratification either by direct evidence which can be in the nature of oral evidence or documentary evidence or circumstantial evidence. In other words, to convict a person under the aforesaid provision, demand and acceptance indicated provision is a sine qua non. That's what, my lord.
No, you are on bail now.
Oh, yes. He retired, I think, 10 years back. Now he came to my chamber limping, my lord. I don't know how long he will last.
No, one thing that also we have also seen,
My lord.
if you have the evidence of Dr. Hazarika, the psychiatric evidence of
Even in Inspector of Police.
CW1.
My lord.
I will not read it aloud.
PW1, my lord.
No, CW, court witness 1.
Oh, court. That is not precise. I did not get it. I did not get it.
It says examination by a psychiatrist in respect of the accused. Accused appeared. Information, as per information, he is suffering from the current problem from February 13. He has withdrawn to self with poor communication with family member, restless, irritable, breaking down into tears off and on and expressing that.
No, he came to my chamber limping that way. The other day he came. Last, I think around 6 months back he came.
Yes, sir. What do you say? Of? Huh? Just a minute. Yes.
Before that, you can take section 20 of PCA.
Presumption.
Huh.
From memory, presumption, if it is accepted.
Now, this conviction to come, this Supreme Court judgment in Neeraj Datta has said, once the demand is proved, once the acceptance is proved, the entire presumption comes.
Yes.
This particular case, the argument is that demand is not proved on 2 counts. One.
In respect to Samson, this is in respect of section 13. This is in respect of section government servant.
7, this is under offense under section 7. No, same.
Section 7. Government servant. If I'm not wrong.
A constitution bench of this court in Neeraj Datta has held that for recording a conviction under section 7 and section 13, prosecution has to prove the demand. So 7 comes in. So that part taken care of. Now, yes, now tell us.
Section 20
Of the PCA, okay. আছে নাকি? এখন পিসি এখন 1988. This matter is prior to 2000. Huh? Presumption. Yes.
And in any trial, offense punishable under 7 or under section 11. This is public servant of an offense is accepted or obtained or attempted to obtain or for any other person, any aspect of contempt from any person, it shall be presumed unless the contrary is really accepted or obtained.
My lord, one thing. He's reading the one latest one, but this offense of 2004, at that one, this was the book.
1988.
He is 88. There's a new one, amended one. 2018 amended. And this is the old one, my lord. This is
in 20, what you are reading.
You read this one, you read this one.
Just a minute, sir. Let me. 2000, You see, that is a substituted, just down below, you'll find substituted by 2018. The matter is prior to 2018. So we'll have to go by the unamended ones.
This one. Lordship may take this one, my lord.
Prior to amendment, what did it?
Lordship may take this old.
Huh?
I will do it again.
There must be some difference, otherwise Mr. Nath would not prove it.
Yes, presumption where public servant accept gratification other than legal remuneration. Where in any trial, often offense punishable under section 7 or
Just need
section
a-
11
number.
of clause A of
No, what
clause
are
B of section 1 of section 13.
Hmm.
Prove that an accused person has accepted or obtained or has agreed to accept or attempted to obtain for himself or for any other person, any gratification other than legal remuneration or any valuable
Yes.
the person itself is presumed unless the contrary is proved that he has accepted or obtained or agreed to accept or attempted to obtain that gratification or that valuable thing as the case may be as a motive or reward such as is mentioned in section 7 or as the case may be without consideration or for such a consideration which is now where in any trial of an offense punishable under section 2, that is
That's all it is. This answer is in the judgment, Supreme Court, I have given copy.
Let him finish. Now you have to show that he had accepted it, if not demanded it, even if we don't go to this judgment, the evidence has to show that he has accepted it.
Yes.
The evidence as we have read. You may like to go through the evidence part, I don't mind, we can have it tomorrow day after. The evidence as in this case we have seen, I went in, I tried to find that particular person who was asking the money, I could not find him, I went to Amodeka. I gave the money on the table. He took the money and asked, what is this for? Immediately the other people came in and arrested him. The acceptance is negated by the question, what is this for? We cannot presume that much of guilt. Taking and putting in, yes, why? Then it's a different issue. He took the money on his hand, what is this for? And immediately he's gone. So that acceptance part perhaps is not. Demand is totally not there.
Yes.
Please.
Paragraph 16
Of
the judgment. Let us now
Let us, you tell us the relevant portion, which part?
relevant portion. Therefore, we have to keep in mind that while speaking every evidence, we have to consider the entire evidence as a whole.
Whose evidence?
The 6, PW6.
No, PW6 has, even in his complaint or even in his cross-examination, he has said, I have never met Amodeka before this. Some other person was telling me that this is for Amodeka.
Exactly. That has been clarified in this paragraph. That is why important. Just also be clear with me. PW6 is evidence in chief deposed that on 18 to 2004, he submitted his application for permit before dealing assistant Amodeka, who asked him to come after 2-3 days. After 2-3 days, when he again went to the office, accused told him to come back after a few days as the work was not complete. After 4-5 days, he again met in the office when the accused told him to meet his sir for permit and asked him to come after some days. The PW6 expressed his difficulties to come again and again from Nalbari to Guwahati before the official. Before the official means Amodeka.
Done.
For the official, then one employee asked him to pay rupees 3,000 for doing the work, as he had already talked with the accused Amodeka. But PW6 refused to pay bribe to the official. If we read these sentences together, we found that by the word the official PW6 is mentioning is accused Amodeka. PW6 is referring the other person as an employee. So there is a clear distinction. PW6 also states that on the day of closing the FIR, before coming to the Office of Vigilance and Anti-Corruption, he went to the State Transport Officer where he met the official who agreed to do the work for 1,800. By taking into consideration of the above in its entirety, we can safely state that by the time the official PW6 refers to equal Amodeka and Nandek. Next paragraph also mentioned. This is important why because it's the sequence of events. I will not go through it, but
I'm just trying to go through 6. Omodeka did not directly demand me for money. In his cross-examination, he says so.
Demanded by the other person.
Huh.
That is relevant evidence from the.
So he did not demand even this 1800.
Now, question paragraph 19 of.
Yes, yes.
In our case, PwC, when the claim chief deposed that on the day of occurrence, he made accused Omodeka on this table, told him to accept the money and kept the money on the table. Omodeka took the money in his hand and asked PwC for what purpose the money is paid. PwC replied that the money is given to his family. In his cross-examination also, PwC reiterates the same. Only above goes to show that on the day of occurrence, Omodeka had taken the money given by PwC. After clarifying the purpose of giving the money, PwC clarified that the money was given to his farming works. Evidence of PwC shows that there was no denial or refusal on the part of the accused. Evidence further shows that the accused has not denied the trap recovery memo by which the bribe money amounting to 1800 smeared with powder was recovered from his possession. All there goes to show suggests that on the day of occurrence, the bribe money of so-and-so was given to the accused, who accepts the same, and the bribe amount was recovered from his possession. That is the finding of the court.
Now, if you do you have the evidence, copy of the evidence before you? I'll just give you the cross-examination part. Come to the cross-examination part of the 6. Thereafter, my application was processed. It took time to process the road permit of a passenger bus. Omodeka told me to meet commissioner as directed by him. I did not meet the commissioner. I did not know the name of the person who came with a file in his hand and asked me to give the bribe. Omodeka did not directly demand me for money for processing my road permit file. On 2-3 occasions, I went to meet the commissioner. I named accused Omodeka in the Azahar because he was the dealing assistant of permit file. I do not know the name of the person who demanded the bribe amount. When I delivered the money on the table, Omodeka, after taking the money, asked me why the amount was paid to him. Immediately, police personnel arrived and caught him. Right? So from here we find that Omodeka did not directly demand any money.
Yes.
2-3 occasions he tried to meet the commissioner, he could not.
Yes.
Omodeka in the Azahar he has named only because he is the dealing assistant and he does not know the name of the person who demanded the money. So the demand part is gone. I'm just trying to, because we'll be upholding a conviction. Here the trial court, tell us if this is not the correct way. The only word that the trial court is trying to depend upon is the word that I went to the official.
Yes.
I went to the official. Had it been Omodeka himself, the informant knowing Omodeka by name, informant having given him it on the table, he would have said Omodeka. He would have said the accused. Why should he go roundabout in a way and say official, and then the trial court come to a conclusion that official can only mean this person?
Yes.
Nothing stopped the trial court from asking the witness directly who is the official. Clarificatory questions could have been asked, not asked, left to imagination, then go home and imagine. So if the demand and the acceptance is not proved at the first instance, presumption has to go. Or rather the presumption will not come in, is what we are feeling at this moment. You don't have a copy of the entire evidence set. We can have the matter listed after a day or two. Because you are only relying upon the judgment to.
For now.
Ha.
He should give some concession to me in a lieu of.
Huh? Now PW6, you see again at page para 16.
Yes.
This 3,000 rupees, na? PW6 expresses difficulties to come again and again to Nolbari. Then one employee asked him to pay 3,000 for doing the work as he had already talked to accused Omar Deka.
Yes.
So this is some employee whose name he does not know, who had demanded the money in the name of Omar Deka.
The corridor he got somebody.
Eh? Then this Omar Deka, let us just view it like this. One person who does not know why the money is on the table. For what?
Can be.
Official, and you bring in the word official to mean him. Would it not be stretching the evidence?
Yes.
Not only what happened with him with the trap case has happened again in the Sessions Court.
Otherwise, already died and all that.
We will say the demand is not proved on him. Official cannot be construed in the manner used to mean only him.
That presumption cannot be taken. That has to be taken to the
Trial court, because the demand
Yes.
was never by Omar Deka specifically. And once the demand is not by him, who made a demand is not identified by the accused. He's smart enough to go to the ACB to find out how to trap a man. And he's naive enough not to know who is demanding money from him. A little far-fetched. There might have been some this and that and
Already the legal hassle that he has gone through.
Huh.
I think.
So, judgment not convincing on the evidence available on record. I do CAV. Yeah, dictation detail.
Now the case is over. I can tell you, Lordship, one thing, my lord. Shall I say? Case is over. Believing third party be very dangerous. What happened with me in one case? There's a case, Lordship knows, Khatkati police station, famous Khatkati police station. So there were around 20 trucks that were carrying excess materials, those wines, to Arunachal Pradesh. Trucks were detained. So the owner of that was from Rajasthan. Somehow the bail tried, failed. Last minute it came to me. Somehow I saw the provision and I found, my lord, those are only 2 years punishment. So cannot be, my lord, the serious type of that one, my lord. Serious conviction, my lord. Non-bailable cannot be. I got the bail. In the trial court, I tried. Then what happened, my lord? My Oshim was with me. He asked me to argue. I went to argue. Finish my case. I came. After 1 month, somebody called me. He said, how much fees you have got? I said, because there are 20 trucks. I said, I got this much fees only. He said, will you believe what happened? Then I will not tell the Lordship what happened. I laughed and laughed and thinking in my name like this. How much unbelievable, 20 trucks, those 20 wheel trucks. I laughed, my lord. I didn't really think, but I laughed. But this is what happens behind. In my name, advocate's name. I don't even know why.
Happens. I heard Mr. Dina. Sorry, I heard Mr. Amnath, learned senior counsel assisted by Mr. Swensu for the appellant. Also heard Mr. Sharma, learned APP for the state. Hearing concluded, judgment reserved. Yes. Sorry? No, what is your ground of appeal?
Lordship.
What is the ground of appeal?
Lordship.
This is item number
49.
49. Was there a mention in the
Yes,
morning
Lordship, in the morning.
that the matter may not be taken up to this?
Yes, you asked us to wait. You asked us to wait till our time.
Yes. Has the conviction been stayed?
Yes.
Huh? He's on bail, okay. Hmm. You are appearing as the amicus.
R2,
The,
the complaint.
the, the age of the victim. Hmm. See this. Medical opinion was taken into account. It was brought from the mouth of the informant that he has a birth certificate of the victim. Eh? Have you seen that? His daughter failed in some classes. There's some law which says that if there is a if there are school certificates, only that will be relied. In the absence, the municipal, and only in absence you will go to medical. Here the very initiation is on the medical documents. Hmm. PW2 that the victim was 19 years old. The moment that 19 and huh?
will not be there.
Ah,
That part is missing in my paper.
which one? The judgment part?
No, the PW, the portion of PW2
No, I'm reading at page 4.
of the judgment.
I'm just trying to so that we are ready on the next day. We have got 2-3 minutes left. Hmm?
Page 4. 19 years old. His suggestion was there.
You see, she had read up to class 5. There's a Supreme Court judgment which says unless and until the school records are absent, the municipal records are absent, do not go for medical. It's the school record which will be the ultimate proof. Why not? When every time when there is an evidence to show that she is read up to class 5 and the father is saying in the cross-examination there is a birth certificate, the very absence will raise a doubt on the age. If the age is doubtful, the POXO is doubtful. If the POXO is doubtful, the conviction is doubtful. If the conviction is doubtful, 2014, should I remand it back now?
No.
The learned, Mr. Mohanto, the learned amicus curiae appointed to assist the court has submitted that the paper book that the paper book supplied to him is incomplete, inasmuch as the statement of the witnesses recorded are not supplied in full stop. In view of the above, the registry is required to verify the paper book which shall be produced by Mr. Mohanto and furnish a complete set of paper books. The registry furnishes it, no? In these cases. Amicus registry in amicus?
Yes, registry furnishes also.
Amicus registry paper book.
Judicial section gives it.
The appeal section gives it. Appeal section gives it, Lordship.
But I think who has to he has to furnish the complete paper book.
No, Lordship.
The registry, I could. What has happened, Lordship, is the depositions are back to back. They've only done the Xerox first part.
Registry furnish copies of report memo and other relevant documents. Registry to verify and supply a complete set of the documents as recorded in the order, as directed in the order dated 18/11/2025. Full stop. List again on. Yes, tell us. Tell us it. Third, huh?
3rd of March.
3rd of March, 2026.
Deeply obliged.
50 and 51.
এটা আছে আইটেম কিমান পিছত এটা লেফট ওভাৰ নাই Yes, madam.
My lord,
this criminal revision petition has come against the order passed by the learned session judge Hailakandi. Originally, the matter was under section 145 CRPC. The learned magistrate, my lord, trial court, my lord, attached the disputed land on the basis of the complaint of the petitioner before your lordship, supported by affidavit as well as police report. And thereafter, my lord, the disputed land was attached. Annexure 1, Annexure 2.
Oh. Third and fourth are holidays. No. 7th of February. Shall we start fixing cases first and third Saturday of each month? Huh? From the month of February. So no, don't keep any fixed matters on that day. We'll keep it on 5th, if not 3rd, 5th. 5th of March.
Pondika Chavale will bring behind it.
12th of March. No busyness on that day. Yes. We will run a little short of time.
The learned trial court, my lord, after considering the complaint petition of the petitioner before your lordship as well as police report and considering emergency in this, attached the disputed land annexure to page 15. Thereafter, what happened, my lord? This respondent second party, he filed a petition before the trial court. Annexure, my lord, that is Annexure 3 and Annexure 4. Annexure 3 for vacating the ex parte attachment order. Then Annexure 4, on the basis of that petition, my lord, the additional district magistrate, Annexure 4, page 20. My lord, I read it, my lord. Case record put up today, the first party member absent without any steps. Second party members absent with steps. The circle officer Hailakandi Revenue Circle is requested to depute LR staff to cause an inquiry about the present status of the scheduled land mentioned below and submit a factual report along with sketch map, copy of Jamabandi if any, and land documents earliest to reveal the actual position of the said land before the next date. My lord, without disposal of that petition, the second party hurriedly filed a criminal revision before the session court against this particular order as well as attachment order. The learned trial court set aside the ex parte attachment order.
Is the land under still, it is still under attachment?
Yes, the minister passed order of attachment that has been attached. Then he filed a petition stating that for vacating ex parte order, stating that he has dwelling house, he purchased the land, through sale deed, etc., etc. That's why, my lord, the trial court directed the circle officer to got the matter inquired and to submit factual report with sketch map, Jamamandi, etc. before the next date. But that petition has not been disposed of. That is an order that annexure.
What we are trying to find out is this.
Annexure, that is an order annexure 4. That the 24/5/2022. So the second party sells this particular order and the attachment order. Ex parte attachment order dated 27/4/2022.
Where is that order? 27/4/2022. Where is that attachment order?
Attachment order is annexure 2. Annexure 2, page 15. Seen the page 15, annexure 2. Seen the complaint petition dated 2/4/22 along with affidavit, Pukalat number and photocopy of land documents duly filed by first party, Sri Sandu Mia, son of so-and-so, resident of so-and-so, Hailakandi. Again, Sri Zahirul Haq Laskar, son of so-and-so and 4 others. Also seen the inquiry report submitted by ASI of Hailakandi Police Stations, which was duly forwarded by the inspector officer in charge in Hailakandi Police Station, Some 25/4/22.
Hmm.
Heard the learned lawyer for the first party petitioner at length. First party submitted a petition dated 22. As per police report, it appears that there is a land dispute in between both the parties, and both parties are dangerous and desperate in nature, and requested to restrain both the parties not to work on below mentioned scheduled land till decision of the learned court to maintaining peace and tranquility. As per complaint petition, first party member stated that he is the lawful owner and possessor of the scheduled land mentioned below by right of inheritance from his father, and has been enjoying the said land without any obstruction. But recently, the second party members have illegally and forcibly trying to grab the scheduled land by disposing the first party. The first party further orally complained that the second party members are dangerous and desperate in nature, and they threatened the first party member with dire consequences. As such, there has been created an apprehension of breach of peace and tranquility between both the parties regarding taking physical possession over the scheduled plot of land mentioned below by the second party members. Under the above facts and circumstances, I am satisfied to draw up a proceeding under section 145 CRPC requiring both the parties to appear in person in court and file written statement WS on their claim over the land along with their valid original land documents and adduce evidence in support of their claims. Further, considering the emergent situation arising in the locality for taking physical possession of the land,
We are running a little short of time, madam. 146 civil court. In 146, we find a reference to the civil court as to who is the actual possessor of the
that is a different
land.
thing.
Now,
Enforcement order has been made.
huh,
Considering emergency in nature,
Huh.
that is an interlocutory order. Against that interlocutory order, no revision lies.
Hmm.
There are several decisions I will show your lordship.
Hmm.
No revision lies against that interlocutory order
Hmm.
as per passed under section 146 subsection 1.
Hmm.
So the learned trial session judge passed the order setting aside that ex parte order. More so, when the respondent filed a petition for vacating Annexure 4, for vacating that ex parte order, stating that he has dwelling house, he purchased the land by registered sale, etc. When the trial court, in order to know the actual possession of the disputed land, directed the circle officer to submit factual report, without disposal of that petition, he hurriedly filed a criminal revision before the session court. That petition still pending for vacating ex parte's attachment order.
Yes, so your ground is that it was an interlocutory order and a revision would not lie.
Yes, number one. Number two, the order passed by the learned session judge setting aside the ex parte order, that is a cryptic order and erroneous, as because page 24, page 24 of the impugned judgment.
We are reading it, yes.
Also, page 23, sorry. No doubt, learned executive magistrate has the power to pass ex parte order and draw up a proceeding and also can attach the disputed land. But the law requires that no party should be left unheard. Only on the basis of police report, the learned trial court should not have passed the ex parte order. On going through the order dated 27/4/22, it appears that the learned trial court drew up a proceeding under section 145 CRPC and thereafter attached the disputed land under section 146 subsection 1 of the CRPC. Whether the dispute is a private or is likely to cause disturbance to the public peace and tranquility is to be decided by the learned trial court, but the fact remains is that both parties are claiming the disputed land as their own. Further, it appears that on 24/5/2022, the revision petitioner appeared before the trial court and prayed for vacating attachment order.
We will have to slow down a bit because the clock is not allowing us to continue much longer.
Pardon?
The clock is not allowing us to continue much longer. Huh?
The matter may be kept further.
Show us that a revision lies. Judgment is there.
There is there. When there is a right is violated, then interlocutory order can be taken. So
When do you want it, madam? When can we have it on the next day?
next Tuesday at 2 p.m.
Next Tuesday. দিব পাৰি নে?
তোমাৰ সদায় problem থাকে। নাই, 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 সেইটোতে কৰা, সেইটো কৰা।
Due to paucity of time, the matter could not be taken up today. The matter could not be concluded today. Full stop. At the request of the learned counsel for the parties. List this matter again on 29th. You are here, madam?
29
Huh?
January.
Huh? On 20.
As per his convenience.
No, not 29th. 29th, we have got quite some few matters fixed.
My lord, it will be better if the matter is taken up on Tuesday next, my lord.
27th, any difficulty?
I will accommodate, no doubt.
On 3rd? On 3rd, madam?
Yes, I am
3rd of,
ready.
3rd of February, who is in? 3rd of February.
Matter may be kept part heard.
Come up before any bench. 3rd of February. Yes.
Much obliged.
May I please your lordship? The appellant is in jail since about 2 years. And the appellant is convicted for 5 years under section 366 IPC and another 7 years for under section 376(1) IPC. And both the sentence will run concurrently. And my lord, here only 6 PW was examined. And initially case was registered under section 366. And mother filed the FIR. FIR is page 15. Mother says that her daughter, when was going to school, then the present appellant along with 2 other persons came with a vehicle, 4-wheeler, and taken her and to the Goalpara. And after 7 days, she was recovered from the house of the present appellant. And thereafter, she was recovered and brought to the Nunmati PS from Goalpara. And Nunmati PS recorded her statement under section 161 and 164 also, and medically she was examined. And thereafter, case was charged sheeted and trial was started before the Kamrup Metro. And the trial court convicted under section 366 IPC and 376 IPC also here.
This is
And-
of to 2024.
My lord?
2024.
Yes, my lord.
Judgment
And,
is dated.
The appellant case is that she is a major girl.
Hmm.
She is a major girl, voluntarily she went
Huh.
for outing. They have good relation in family relation.
Huh.
And subsequently they have filed this FIR. And initially she stated before the police when she was recovered. The PW4 stated that no physical relation was established. The IO stated before the court. When we recovered, she did not state us that physical relation because she kept with her mother. And there was a time to come, and immediately they could not come to Guwahati, then lost the FIR. And the other section, 366 also not paid out here because the no eyewitness was examined here except the parents, and they are the hearsay witness. And parents and the victim.
Eyewitness to what? 366 and 376?
No, 366 meant the public place. A public place from at
The
least
place
some-
may be public. The place may be public place, but public may not be there.
But source maybe come out, any person may say, yes, something happened here. So on friend of the girl, that is now Bobita, and she was also not examined because Bobita reported. Mother, the police did not examine him. And who is the police recovered from the Golpara house? my
When
lord?
can we take this up?
Acha.
Looking at the time, when can we take this up?
28 or 29?
I have been asked not to fix 28 or 29 because we have fixed quite some few matters. 5th? 5 দিব পাৰো, February 5? February 5 ৰিফ্ৰেছ কৰক। Today I saw a petition, this is out of the context. The witness was reproduced in the court. I could not help smiling. It was not the witness was produced again. The witness was reproduced in the court. Huh? কোন তাৰিখত? No, 29 না 5 কৈছো. How? Fifth full. Fourth we can try. Fourth also no, not fourth. গোটেইবাৰ মই ফিক্স কৰিছিলো ইমান ফটাফট বাপৰে বাপ. 11th. 11th of February.
Yes, go ahead. Maybe kept a part hard minute.
Huh?
No, kept
Nowadays, Parthard does not tie the case to us. We get tied to the case. Huh?
I'm blessed with it.
Judgment la disable কিবা এটা আছে. No, hey, মই কলো হেৰি দিব নেকি? Pena 22. Here it is already 304 part 2. So
No, it was, initially it was 302. Then
High Court made it 30, but in this, in our particular case, the conviction is already under 304 part 2. 304 part 2, sorry. 304 part 2. So if that is so,
Even, I think.
therefore, the leniency was shown in bringing it down to 3 years.
Yes.
Now with the prolonged litigation, we can try to bring it down a little more.
Because the.
Now, after 20 to 25
Yes.
years,
There it has been.
it to 47 to people.
Huh? Been offered by.
কি দিব তাতে